complaint, the provisions are that I have to go before them, make that allegation, they will inquire.
Who will inquire? Who will inquire?
DGCA.
DGC.
And who are you, Mr. Rawal? Who are you?
Lord, I am the Mumbai airport.
Oh.
International airport.
So, Airport
Fine.
Authority, can I just take my lords? Only 1 minute, my lords. Give me 1 minute, my lords.
Granted was in 2006.
Just a
My
minute.
lord, that is, can I just,
And who are you, Mr. Power?
my lords, I am the developer of the first Gautam Society. I built 16 floors. It is a case of Airport Authority of India that there is violation of the height, permitted height by 2 floors. Give me 2 minutes, my lords. So I moved the High Court pointing out the NOCs granted by the Airport Authority of India.
Your original plans
Yes, my lords.
shows these 2 floors?
No, my lord, can I just say? Initially, plan given, approved was 12 floors. I gave a revised plan for 16 floors.
Approved?
Approved by the municipal corporation, constructed.
Did the airport authority and all granted you the permission?
No, my lords, I
No.
do
Who revised the, who granted,
Municipal corporation.
who sanctioned the revised plan?
but the municipal corporation has to grant the sanction to the revised plan.
Now, at that relevant point of time, they didn't ask you to get NOC from the airport authority or DG, what is it called? DG?
DGCA.
DGCL? No?
Was rejected.
My lords, very honestly, I am not aware at the moment, but kindly
just a
consider.
minute. Step by step.
Yes, sir.
Okay. Now, he has nothing to do with
No, no,
Gautam.
no. He's in the adjoining
What is that name?
Shubh Hari Darshan Society.
Shubh?
Hari Darshan.
Not connected in any manner.
Can I just, therefore, I wanted
So you are now developing Shubh Hari also?
No. My friend, please allow me. My friend has not informed your lordship court. I was to develop Shubh Hari as I did for Gautam. In 2019, I approached him. He's a developer builder. Residing in my friend's client, he is admitted residing in Pali Hill in Mumbai. Pali Hill in Mumbai. My friend says, before your lordship court in the
My
counter,
brother knows Pali Hill.
so Pali Hill, he resides. And on affidavit, he has informed
Okay.
last time. So
He-
I approached him in 2019, my lord, saying, sir, I cannot develop. You are an influential builder. Would you like to develop it? He said yes. So an agreement is executed in 2022 to construct Shubhari by him for a consideration of 22 crores. As against 22 crores, he said, you can give me the properties once it's developed.
Have you paid him something?
No, my lords. Can I just give me 2 minutes? My lords, the agreement was I have to pay him 22 crores. He said, don't give me this money. Instead,
The entire building belongs to him.
no, my lord, he had to develop it and then sell it. Shubh Hari was to be constructed.
He was occupying one flat in this.
Five.
Shubh
No,
Hari.
my lords, kindly.
5.
5. I was the owner of 5 flats. Sir.
Total 11 members only originally before redevelopment in Shubh Hari. Out of 11, he bought 5 members' rights before it was demolished. Thereafter, in 2022, I approached him saying that you are a builder. Would you like to develop this property, redevelop the property? He said yes. Agreement has been executed in 2022, under which I had to pay him 22 crores. He said, don't pay me 22 crores. Instead, you give me redeveloped rights over the built-up property of 7,000 square feet, which I accepted. Contract is signed in 2022.
Now, who has gone before the High Court?
I tell my lord. So, my lord, this is one part. In Shubh Hari, give me 2 minutes more, my lords. In Shubh Hari, there was an arbitration. This agreement was in 2022 with him. He did not make any construction. Nothing was happened. So I terminated the contract in 2025. My friend's client approached Section 9 court, Section 11 court. High Court in November 25, just last month, appointed Justice Qureshi as arbitrator between us. All these facts, construction agreement, dispute, termination, High Court order, arbitration, suppressed from your lordship's court.
Is it true?
My
True?
It should have been.
What is this, my lords? This is absolutely improper, my lords. You don't state correct fact before the court.
Then what do we do with Gautam?
I'll answer straight away.
No,
Gautam.
wait a minute.
I'm sorry.
When he is concerned with Shubh Hari,
Yes, my lords.
why Gautam is in picture over here?
Moved an application, Bombay High Court. Give me 1 minute.
Have
May I-
gone challenging these orders.
May I,
which are
may I,
part of
may I
the
just
complaint.
say, may I just say, sir, in Gautam, I moved the High Court in writ jurisdiction. In 2021, pointing out that, sir, the authority has made an order to me to remove height of X area on the top of the property built up. But the authority has granted NOC in the adjoining buildings of 77,
It's all right. You appear today for
respond number 1 and 2.
Take down.
Plus, can I just make one submission?
See,
Because I'm, that's why your lordships asked me whether I have suppressed plus I have suppressed it. There are two capacities.
Now, we'll finish it off. Take down.
my lord, I have one, my lord.
We are taking care of your problem also. When this matter was heard for the first time, an impression was given to the court that the petitioners who had flats in a society by name Shubhari have been left into lurch by the developer, more particularly after the entire apartment was demolished, and there has been no further progress insofar as redevelopment is concerned. In such circumstances, although the order impugned before us passed by the High Court is a very innocuous one, we thought fit to issue notice and try to understand the dispute between the parties. Mr. Naveen Pawar, the learned senior counsel, appeared today on behalf of the respondent numbers 1 and 2 respectively. After hearing Mr. Parmeshwar, the learned senior counsel appearing for the petitioners, and Mr. Pawar, the learned senior counsel appearing for the respondent numbers 1 and 2, it appears that the petitioners and the respondent numbers 1 and 2 are already in an arbitration proceedings before the learned arbitrator, Honorable Justice Akhil Qureshi. All disputes between the parties are now a subject matter of arbitration. In such circumstances, we do not want to say anything further in the matter. It is now for the learned arbitrator to proceed and pass an appropriate award in accordance with law. There is another issue tagged with this litigation. This has something to do with a society by name Gautam. Insofar as Gautam Society is concerned, originally the developer got 12 floors sanctioned. Later, a revised plan of 16 floors was put forward before the Bombay Municipal Corporation. The Bombay Municipal Corporation sanctioned the revised plans and permitted the developer to put
Minus,
4 more.
I
Huh?
want to make a statement.
Yes.
The BMC has not approved
That's
the.
right.
No.
I have to put my counter affidavit for.
अच्छा अच्छा क्या लिखा आपने? हाँ. हाँ. Later, a revised plan for 16 floors came to be placed before the Bombay Municipal Corporation for sanction. According to Mr. Pawar, the revised plan has been sanctioned and permission has been granted. Whereas on the other hand, the learned counsel appearing for the BMC disputed and submitted that no sanction, the revised plan has not been sanctioned.
I want to file my counter.
Full point. The problem with additional 4 floors is also with the airport authority.
The NOC granted
By the-
initially by the airport authority on 18/5/2000.
Full point. Airport authority. Full point. In such circumstances, let the High Court look into the matter and do the needful. Full point. You all are parties before
Yes,
the
sir.
High Court?
All of the parties.
Fine. We need not adjudicate this petition any further. Close the matter.
Please,
Petition
sir.
disposed.
Image to
Can
apply.
I only, my lord, request, my lord, that it could be done not in some reasonable time.
Why do you worry? He has not put up the floors.
Let's put up.
That's what, my lord.
Put up the
He
floors.
put up the floors, he applied
Since,
for sanction.
since the developer has already constructed additional four floors without getting the revised plan sanctioned, and there is a strong objection at the end of the airport authorities, we request the High Court to take up the matter at the earliest. And after hearing all the parties concerned, decide the same in accordance with
Please,
it.
Your Lordship. Much obliged, Your Lordship.
Great.
Let's,
Shubha Hari Darshan.
My lords.
let's, plus I just one submission. Apologies for that suppression. We go by our instructions.
Mr. Pava, chalo, we accept his apology. You have put up 4 floors without the revised plan
Lords,
being sanctioned.
Friend is not right completely. I have the permission saying.
This things 2 cities, Delhi, home buyers, sufferers, thousands of thousands. And in Bombay, this redevelopment. Except Bombay and Delhi, we don't find this type of litigation in any other state. Have you come across one such case in Gujarat?
Yeah,
No.
there is none.
Not a single litigation at the end of the home buyers from Gujarat.
None, my lords, none. Lordships are right. Lords.
See the reputation of the builders, developers over there. Bombay, you put up construction without any plans.
There is some explanation which I can owe, my lord.
No explanation. What were you doing, ma'am?
They should know.
Where were you?
No, they should know.
When he put up 13th floor, where were you?
My lords,
When he put up 14th floor, where were you?
But-
15th floor, where were you? 16th floor, where were you?
my lords, we tried the demolition
Oh,
and we have the status report as well. So, the floors, the extra floors over there, the people who owned them were not there, so that we can carry on the demolition.
so what do you propose to do now?
My lords, we have, I need to,
Will you do it? Okay, we order.
my lords, we have, I can file the status report along with the petition.
15 they passed an order.
Next matter.
Please, Your Lordship.
Next matter.
Much obliged to the lords.
This matter will take it up tomorrow.
Yes.
Brother. Take it up tomorrow.
Monday, Mil.
Huh?
Monday.
I'm sorry, Monday.
Yes, yes.
Lordship, Monday, brother, you Monday you are on leave. Then keep it on Tuesday.
Lordship.
Very.
Hope there are some developments in the matter.
Milord, they have filed an affidavit,
the
Milord,
selection
may
committee
not
has
be in your
given-
office report, Milord.
The selection committee has given 2 sets of names.
Uh-huh.
The chancellor found 2 names figure in both the universities.
Then
I thought that
sit
name
and-
should figure, but I believe
Yes.
the chief minister has some difficulty with these names. So I
Milord,
wanted to know,
Milord,
chancellor
the
wants-
very name that the chief minister had indicated was not acceptable is the only name acceptable to the chancellor, Milord. I think it's heading for, Milord, a resolution by the Lordship.
Wait a minute. The committee which we constituted
Yes.
has recommended 4 names.
In the
4
first
5
university.
names respectively.
4 names for one university and 4 names for the
Correct.
second university.
And 2 names figure in both for the university.
By Tuesday, if you all can work it out,
Yes.
well and good. Otherwise, we will appoint.
No, I have no difficulty. Chancellor says if the committee has 2 names figure in both the lists, I think probably the best candidate to be recommended.
But
So
That
the
should
chief
be ordered,
minister, one,
Mr.
the chief minister says, I'll go with some other
Venkatramani,
names.
you all will have to reach to some consensus.
No, I will be able to do that.
If
What I-
you all are unable to reach to some consensus, then the intervention of the court is the only option
No, I think we'll try to avoid
as far as
that's right.
possible.
That's right. All that the chancellor needs is if those records which went before the selection committee.
Any
is
good
made available-
expression other than as far as possible? Any better? You have a
No, in
superb vocabulary.
You know, in fact, in West Bengal, we have cleared about 70%.
Something beyond as far as
I
possible.
know that we,
Thank
in
you.
order, one small request, Your Lordship.
Okay.
One small request.
Mhm.
The Chancellor, in order to place his points of view,
Ah.
the records that before the selection committee is placed before him, he'll be able to say, am I right or wrong? I only want the records to be
One-
before him.
One most meritorious is to be appointed in one university and one most meritorious in the second university.
That's what the Chancellor also wants. The Chancellor says if two names figure in both the lists, should they not be preferred? That means two selection
Mr.
committees
Gupte,
have found them
just work it out.
meritorious.
All right.
Work it out. Work it out.
Before I disturb your lordship, my lord, I'll sit with with the attorney.
Work it out.
So let's just keep it. I believe the Chancellor is not available until a day or two later. I believe for the Chancellor, it is
Thursday,
probably on route.
top of the board.
Wait.
7, there is a letter.
Item number 8, I have a request to make. Not same order is challenged by our client, which is numbered. Would my lord consider of taking this matter and my matter my lord, together next week or any other day suitable to your lordships? We are the original plaintiff, so my lord, the proceedings are initiated at our behest.
What there, sir? First. 6. Respondent 6, is it? Sister. Your petitioner? Your petitioner? No. Okay. Yes, okay, your respondent.
What is the position today? After measures Rado Construction sold the property to respondent number 1, your client.
Yes, my lord, sir.
What is the position
So-
thereafter?
The difficulty is the counsel for the petitioner, he's down with high fever since last night, so we are not, I'm indisposed to go on with the hearing. And also the plaintiff have filed their SLP, which
My
is
petition
pending
also is numbered,
scrutiny.
which also may be taken together.
Whether the leasehold rights
Yes.
should have been
Whether they have and what is the effect of it, my lord, on a LOI for a slum
so
development?
when the original lessee dies,
Yes.
what would happen to the leasehold rights? They would get automatically transferred to the legal.
That's
heir?
what the legal heirs are saying after 40 years, my lords, because because lease expired in 52. Lease was for 4 years, my lords. And it's a slum project. I have the photographs. It looks like a slum like this, my lords.
Okay. To Mr. Kama? You are Mr. Kama?
Tikku,
Mr.
T-I-K-U.
Mr. Tikku.
Tikku.
Tikku. KU, sorry.
K-U doesn't matter. Now,
Put it on Monday week.
Monday.
Please me.
Obliged.
May I give the number so that it will come together? The other
Take-
petition.
Great.
you haven't served copy of that.
We will, my lord.
Get it, sir. Please. Sometime.
Item 9, it's an award of 2016. That they haven't deposited any security amount.
Beg your pardon?
This is an award of 2016. Until that nothing, after the 34 has been passed, they said it's an automatic stay. I filed an execution. The execution gets,
You are the award holder.
yeah, I am the award.
What happened in 34?
34 is pending till date.
Before the High Court?
No, before the district court.
Then why you had to go to the High Court?
Because nothing was happening there, so I approached the High Court to expedite it.
What is the number of that 34 application?
34 application is 16. Just a minute.
Where do we find this? Annexure?
Page 71. Not 70.
What is the amount awarded
1
to
of
you?
17.
What is the amount awarded to you?
About 75 lakhs
With interest?
with interest, pendent right and future.
Okay. When the 34 application was filed, the award dater must have prayed for stay of the execution. Na?
No, there was an automatic stay. This is.
What do you mean by automatic stay?
My lordship may see the order.
Automatic stay?
It's at page
This is under the Arbitration Act, na?
71.
71?
Page 71, annexure P3.
Who has passed this order?
This is by Patiala House, Winklewood, ADJ.
And you have not preferred any execution?
I have,
petition?
it is also stayed. My execution of 17 only. And I have the last order of the execution, which says into 2024.
What do you mean by pre-amendments, pre-amended section 36?
That is that in 15, there was an amendment.
So pre-amended, there is something called automatic stay on the execution.
That's,
Assist us. We are not aware of it.
so there is no automatic stay as such.
We heard Mr.
Siddharth Chaudhary.
Learned Counsel appearing for the petitioner. He invited our attention to the order passed by the District Court, New Delhi, dated 6/12/2018 in arbitration number 5307 of 2017, which reads thus. Quote that order, which is at page 71. It appears that the petitioner before us has an award in his favor of the amount of rupees 75 lakh with interest. The award data has preferred an application under section 34 of the Act. Since then, the proceedings are pending before the district court. We are of the view that the court concerned should now take up arbitration number 5307 of 2017, hear the parties and pass an appropriate order within a period of 2 months from today. The disposal of arbitration number 5307 of 2017 by the District Court, New Delhi, shall be reported to this court. Next matter. Wait a minute. Okay.
Should have been time more.
So take notice of the fact that the High Court has exactly done the same thing what we have done today. The High Court's order reads thus. Okay, fine. Sure.
May it please me. Because this proceedings arises out of an order passed in execution proceedings in an arbitral award. Lords, award is, I'm the claimant before my lords. The claimant has succeeded and has the award in his favor, my lords. The 34 is dismissed, my lords. At the stage of execution, my lords, the executing court asks the decretal amount to be deposited in court. That straightaway challenged 227, my lords, before the Honorable High Court, my lords. Lords, there are 2 or 3 propositions, my lords.
No.
Yeah, so sorry.
There's an award.
Yes, my lords.
34 dismissed.
Dismissed, my lords.
What happened in 37?
37 not filed, my lords.
Not filed.
Not filed.
You go for execution.
I go for execution, my lords.
In execution, what did the High Court do?
No, in execution before the trial court in Odisha, my lords.
Then what did
The civil judge senior division directs them to pay the deposit decretal amount in
that
court.
order is challenged in the High Court?
227 before the High Court.
And what does the High Court say?
The High Court, my lords, supplants the order completely.
That this is that BSNL
Yes, my lords.
notice. Notice. Take it.
Because the High Court has completely amended the order of the executing. May I pray for stay of the executing court's order?
Then what will you do?
My lords, because
Proceed with the execution?
no, my lords, I will not proceed. Let the execution proceeding be stayed in the meantime, because they have altered the executing proceedings and said you proceed.
In the meantime, the execution proceedings pending before the court of
My lords, it's civil judge, junior.
shall remain stayed. Next matter.
Much obliged.
May I please, my lords? My lords, I am aware, my lords, the arbitration award against me, my lords, has been rejected by up till this, my lords. My lords had dismissed the SLP against the 37, my lords. My lords, this SLP is only on a very limited point, my lords, when the payments were being made, my lords. The calculation as
But, ma'am, Where is the original order? This is a review order.
I am, that's my lords. My lords, the original
Against the original order.
award, my lords, 34 was dismissed, 37, the SLP also, my lords, have
Now, when
dismissed.
the SLP came to be dismissed,
Please, my lords.
it was summarily dismissed.
Yes.
No, my lords, it was a in limine.
So then you could have preferred a review application.
Please, my
Your
lords.
review was maintainable.
Please, my lords.
The doctrine of merger will not
Please, my
apply.
lords. Please, my lords.
Now you are seeking to challenge the order passed in your review application.
Please, my lords, the order has been dismissed on, the review has been dismissed on delay, my lords. And the limited point is only as far as the calculation, my lords. And I would say why so? Because, my lords, the arbitration award.
What was the error according to you in
My
the
lords,
original?
The arbitration award proceeds on the basis of awarding the respondent money for the central services centers which it had put up for 594 units, my lords. But by their own, that was the benchmark, and a bench and a cutoff date was listed, my lords. But the respondent itself, in the invoices which it had submitted to the state, the CSCs became functional over a period of time.
So your review was not decided on merits.
Please, my lords,
It was decided only on the ground that there is a delay of
Please, my lords.
429 days.
Please, my lords. And the reason, my lords, the execution, because, my lords, these points, the execution cannot go behind the.
What
my
happened
lords.
in execution?
My lords, it's pending. They have.
What is your liability?
My lords, we have paid the principal of 7.91 crores as far back as in May of 2025. The interest, my lords, because the interest.
What is the amount due
difference
in?
would come almost around 1.13 crores, my lords. The difference.
You have to recover.
Let's just indicate the principal amount has been given. Interest was 12.34 crores. They have given 11.21 crores. Now, principal of 6.60 lakhs is the only which has come forth. But more important, my lords, there is principal of some 6.6 lakhs, which is left out of 10 crores, my lords. That is all they are here for.
How much you have to recover now?
My lords, I have to recover close to around 1 crore and odd, my lords.
Yeah, 1.13 is my
1.13 crores I
calculation.
have to recover.
My lords, is
My lords, this is SLP is not maintainable against a review. I'm sorry, my lords.
Why? Why not
My
maintainable?
lords, against only a review order, your lordships have repeatedly held SLP is not maintainable. Only against a review order. I have orders, my lords. Lordship has been consistently holding this.
And her original order, the court
Especially,
has.
yes, because it's
That-
traveled
that
up to your
I've
lordship
pointed out.
and that's been dismissed.
That's the problem.
I bow down to that, my lords. I'm just that because the execution court could not go behind the award. This is only, my lords, it will be unrich enrichment of public.
Nahin, nahin,
That's
not
all. That's all.
My lords.
Because, my lords,
Interest cannot be termed as unjust enrichment.
because they had not set up the entire units for which they are being
Dismissed.
that.
Next.
I'm so grateful.
Dismissed.
My lords, I
You did well, ma'am.
Grateful.
You have a weak matter.
most obliged.
Please, Your Lordship. The petitioner Jilla Parishad is running a school, primary school, on the disputed land since 1955-56, my lord.
You have a sketch?
Ha-
Do you have a sketch?
yes, my lord. The color
Show us
and sketch
where is
96.
the school situated and what is the extent of the land surrounding the school?
So near about it is a 2,500 square feet. That is, Lordship, may kindly say page number.
You are
97.
appearing for the school.
For Jilla Parishad, we are running this school. Jilla
You are appearing for the owner.
Original plaintiff, yes.
How come that you permitted them to put up a school?
Lord, that was there is a background of that, my lord, sometime in 95.
Now, just listen to me. According to them, they want to undertake some repairs.
No, my lord.
Yes, ma'am.
Then
They want to build 2 extra rooms, additional rooms.
Fine.
The building permission also.
school is
Primary school.
But, my lord, my suit is pending. In my suit, my lord, for ownership and possession, they take a plea of adverse possession.
Concurrent
They
fine.
negotiated and sorted out. My lord.
that plea can be rejected.
That has been
एक
rejected.
काम करो इन लोगों को मीडिएशन सेंटर पे भेज दो.
Certainly, my lord, that's the way, my lord. I see
Next
that. My
matter.
lord, they can't.
Next matter.
Please, my lord.
My lord, this is a case where the impugned order, the facts are slightly convoluted, but if I may, I can simplify them.
Temporary injunction, Miss Narima.
Yes, but what have they done through the temporary injunction, my lords? What they have done is injuncted 3 acres when all the plaintiff claims was 1 acre. How do you injunct?
Are you
I have
all
a sale deed.
Are you all related?
No,
No, ma'am.
not related parties.
Then
I have a salient that's why I wanted to explain the facts. They're slightly convoluted, but my lords, I can explain them in a slightly simplified manner. There were 7 acres, my lord, approximately 7 acres, 7 acres, 20 guntas. There were approximately 7 acres, which through a compromise decree came to be owned by 2 parties, my lord. One of those parties gets
Who are the
approximately.
plaintiff?
No, they are the plaintiff.
They are the plaintiff.
Yes.
They have filed a suit for what?
They have filed the suit for two reliefs, my lord.
3 reliefs, my lords.
What
They
is
say
that?
declare me as the owner of my 1 acre.
Correct.
That's one plus 9 gunta.
Then
The second is declare that my sale deed, which is completely independent of theirs,
you purchased it from whom?
I purchased it from a separate person. That's exactly why I wanted to show my lords the chronology of events.
And
I
what is the
purchased it from
third?
one of those 2 people in the
What
separate.
is the third?
Injunction.
Yes.
my lords.
And the third is injunction, my lord. So the 2 primary prayers, one.
So out
injunction-
of 7 acres,
Yes.
we are only concerned with 1 acre.
They are concerned with only 1. We are concerned with 3. And they are in fact separate.
And what about the balance 4 acres?
The balance, in fact, that's what I will just explain. What has happened is the 2 parties, my lords, who divide it, one divides it 4 acres, the other person gets 3 acres. Out of the 3 acres, they sell 1 acre to them, my lords. The person who gets the 4 acres in that original compromise.
Today, if we vacate this order,
Yes, my lords.
interim injunction order,
Yes, my lords.
what would you do with the?
In fact, that is
back?
precisely what I will come to straight away. We are both companies. We are both looking to develop this as far as I can see, my lords.
Okay.
The 1 acre
Listen,
is on their side.
listen.
I have 2 acres.
We have a way out.
Yes, my lords.
This is going to be a long drawn litigation. You are still at the stage of Exhibit 5, Order 39.
Yes.
Suit is yet to be tried.
Yes, my lords.
First appeal, whatever it is.
Yes, my lords.
Go for mediation. Settle it out.
My learned friend is the seller. The buyer from her has not approached your lordships, my lords. So she has sold, my learned
They
friend's
filed
client has
against me,
sold,
though.
they
And
have
it's still
sold the
false
land and
also.
gone.
We've
There's no mediation with them because the mediation will have to be with the buyer.
I want to get rid of this litigation.
No, I bow down, my lords. I'm only praying, my lords, that mediating with my learned friend's client.
If we don't interfere today,
Yes, my lords.
the suit will remain pending.
Yes, my lord.
The interim order will continue.
But then, my lord,
She will keep contesting.
my
right?
learned friends.
One fine day, there will be either a decree in your favor or it could be a case of dismissal.
Foreseeing that, my lords, of what is following. But I can't mediate with her because she has sold a lot of land and gone away from, taken the money. Her buyer is the one I have to mediate with.
The buyer will also join.
Yes, that is Z and S one. He's not here. He's not approached your lordships.
What is the name
They are
of the buyer?
responsible for in this case.
But they have not approached. The seller has approached
It's all
your
right.
lordships.
It's all right. So will you all go before the center or we should appoint someone? I think that would be a better option.
Where is this?
My lord, I will leave it to my lords.
Hyderabad, who's there?
This is from which place?
Hyderabad.
My lord,
Hyderabad.
Hyderabad center is what's being suggested.
No. Hyderabad.
Anyone?
Some retired.
Yes,
High Court
that in
judge.
fact always.
Ask your inspector.
Justice Naveen Rao, they're suggesting. I leave it to my lords.
Justice Nageshwar Rao, though not from Hyderabad, but
Yeah?
he's here. So that
Take down.
He is super.
let be here. Better yahin karo.
He'll understand.
This petition arises from an interim order passed by the High Court of
Telangana.
Telangana dated 21/5/2025, by which the civil miscellaneous appeals preferred by the petitioner herein, bracket, a partnership firm, came to be dismissed, thereby affirming the interim order of temporary injunction granted by the trial court in favor of the respondent numbers.
Respondent numbers, respondent 2, my lord. One, sorry.
Respondent number 1. Full point. We heard Ms. Nina Nariman, learned counsel, appearing for the petitioner, original defendant. and Mr. Siddharth Dave, the learned senior counsel, appearing for the respondent number 1. Full point. We are of the view that this is going to be a long drawn litigation between the parties. In such circumstances, they should go for mediation and get the entire disputes and get their disputes resolved. It is necessary for us to take note of the fact that the respondent number 4 is now the purchaser of the subject property. He is not before us. The respondent number 4 is not before us. However, since we want the parties to go for mediation, we direct the respondent number 4 also to join the mediation. In view of the aforesaid, we appoint Honorable Justice Nageshwar Rao,
L. Nageshwar Rao.
L. Nageshwar Rao, former judge of the former judge of
this
Supreme Court of India, to act as a mediator between the parties. Full point. The fees of the learned mediator and the other modalities shall be worked out in consultation with the mediator. Once we receive the report of the mediator, we shall proceed with the matter further.
Lordship, please.
100% it will be resolved.
Yes.
Next matter.
Much obliged.
Grateful, my lord.
It has to be restored, my lord. They're all above 5 crores.
Restore them.
Obligation. Obligation.
Mr. Joshi is joining online.
Please, your lordships, I beg to appear for the appellants in item number 15. My lord, this is an appeal that challenges an order of the NCLAT dated 11th August 2025, which granted a clarification to its earlier order of April. Now, I must point out to your lordships that on 9th September 2025 at Annexure A2, your lordships have taken note of this fact in other connected appeals, which are likely to come up in January 2026, my lord. Can this appeal also be taken up along with the other connected
That
appeals?
we have taken note of it. What
Yes.
is this, Mr. Jain? Some amount is reduced.
No amount is reduced. Whatever was to come to me is coming to me. Whatever was to go to the interim trade creditors was to go to them. The
अच्छा एक काम करो टैग कर दो next week में रख देना.
Grateful.
And Mr. Joshi,
Lordship pleases.
next time you remain present in the courtroom.
I will, my
We
lord.
have to hear you in the matter.
My lord, I'll be privileged. I'll come to Delhi. Grateful. I'm
Great.
obliged.
Look here, but I'll show 34 court doesn't give any reasons. 37 court doesn't give any reasons. But please see, my lord, only one example. Award at page 243. 37 is a regular first appeal. But I may show that first, how the first appeal is decided. Please come to page 21.
No, are you aggrieved by the relief which has been granted by the High Court so far as clause 18 of the Vivad Se Vishwas?
No.
Huh?
I am on the Vivad Se Vishwas scheme would apply if appeal is not pending. My appeal is wrongly dismissed without any reasons.
No. Come to para 19. Come to
19.
para 19.
Yes.
High Court posed two questions for its consideration.
Correct, my lord. Correct.
Whether this court should interfere with the impugned order given in the narrow scope of its powers, right? And two, whether clause 18 of the Vivad Se Vishwas is mandatory in nature.
My lord, if
So far as the first question is concerned, it has gone against you.
Yes, my lord.
So far as second is concerned,
It has gone against me because it is a consequence of
right.
one.
Now what is your submission?
Yes. Lord, first, kindly see first question. Section 37 appeal. Correct? I'll go reverse. Lord, please have a look at page 21. 37 is a first appeal, the full-fledged appeal. Now, please see page 21, how my appeal is dismissed. Para 53. First, my lord, please consider this is a final order, but it starts with prima facie, your lordship finds. But this is not my best point. I'm just pointing out. Para 53, your lordship gets.
Just a minute.
Page 21, para 53 of the impugn order.
Para?
53.
Yes.
This is my regular first appeal is being decided. Please see this. Prima facie, a perusal of the impugned judgment and award unequivocally demonstrates that the arbitrator relied upon written submissions, documentary evidence, and the statement of the parties involved in the transaction to determine and quantify the claims. The learned district judge has first and foremost taken note of the scope of its powers under Section 34 of the Act and the settled position of law pertaining to the grounds where it may exercise its powers, which is in line with the position of law laid down, so and so, so and so. Then 55. Thereafter, the learned district judge has taken note of the contentions of the parties, including the law relied upon by either side. Then the learned district judge applied its mind and, referring to the findings of the learned arbitrator, has come to the conclusion that the learned arbitrator has arrived at its finding after due consideration of documents on record, the agreement and the evidence adduced by the parties. Such a finding having been arrived at, it cannot be trifled with the absence of glaring error.
Understood. Your argument is that it's a non-speaking order.
Non-speaking order. Now please see, my lord, 34. How 34 court decides. Page 311, para 17.
Annexure?
Page 311, para 17.
Annexure?
Annexure P10, my lords.
Yes.
Lord, page 311, my lord, PDF would be 341, my lords. I'm sorry, there is a difference in pagination because of.
Yes.
Para 17, your lordship gets. Para 16, my lord, I'll read para 16 first. The honorable arbitrator.
What type of award is this? Money?
Money.
What is the amount?
13 crores. The
Who was the arbitrator?
One former judge of Orissa High Court.
Who are you?
Lord, I am the PSU.
And who are you, Mr.
I'm the contractor, my lord.
Contractor.
My lord. The claimant.
Your full claim has been allowed?
No. Substantially low, my lords. And since 2000.
Only I'll point out. I'm going reverse. I have shown 37. Now I'm showing 34. And then I'll show the award. Kindly see 310.
Where was 34 order, may see? It's an exhaustive 34 order.
What is
award?
Let us see how 34 is exhaustive. Only a minute. Let me read. Let us read. Rather than
34.
Whether it is.
Just ordinarily, we should not interfere. Come to para 15.
Yes, my lords.
Come to 15. Up to 14.
Yes, my lords.
The 34 court records the submissions.
Yes, my lords.
Now read 15.
Yes, my lords. The honorable arbitrator, after discussing the evidences raised by the parties, held that the delay in giving possession of the site will exonerate the claimant from completing the work within stipulated time. The giving possession of the site is clearly a condition precedent to the contractor proceeding with the contract work, and there must be an implied, if not expressed terms, that the site will be handed over to the contractor. In this case, there is an express condition, clause 18.1 of the conditions of contract, which stipulated that the site can be provided in installments, but this does not give liberty to the respondent to give site after expiry of the stipulated period of completion.
So what was your grievance?
My grievance was site was not given to me the entire term of 15 months which was given to me to complete the work. Site was given after that. And on top of it, they imposed LD upon me for the delays on my part.
Liquidated damage.
On me, 96 crores. I mean, agencies were appointed by them.
So you were unable to undertake the contract.
No, but we did some part, but then we could not do it because of the contract was terminated with them.
Fine.
Sooner thereafter, I'm sorry.
Now, what is your case, Mr.
Yes, my lord, kindly see, my lord. This is the para your lordships have read. Now further, my lord, and I'll show, my lord, the shocking, my lord, the finding of the arbitrator, not even taken note of. My lord, para 16, the honorable arbitrator interpreted some of the clauses of the agreement and gave his own views in reaching to the conclusion, but such interpretation of clauses of agreement is permissible under the law. Then, my lord, 17. Then 17, on close scrutiny of the arbitral award, it is found that the award is not against the public policy and there is no apparent mistake on, apparent mistake is otherwise also.
Would you all like to talk and resolve it?
Because can I request
I
one thing?
don't think, my lord,
I can't-
can I, my lord, show one thing?
Okay, issue notice. What's, Mr. Rodgi,
Yes, my lord.
your good name?
Nikhil, my lord. My first name is Nikhil.
Mr. Nikhil Rodgi, the Learned Counsel, waives service of notice for and on behalf of the
sole respondent.
Sole respondent award holder.
Respondent number 1, my lord.
Respondent number 1, award holder.
Union.
Union is made as respondent number 2.
Union of India was a party because of Vivad se Vishwas.
Beg your pardon?
Union of India is respondent number 2 because
it's all right. क्या लिखा आपने? नहीं, ये लिखिए. We heard Mr. Tushar Mehta, the Learned Solicitor General of India, appearing with Learned Counsel for the petitioner, and Mr. Naveen Pava, the Learned Senior Counsel, assisted by Mr. Nikhil Rodgi, the Learned Counsel, appearing for the sole respondent.
Respondent number 1.
Respondent number 1, award holder.
My lords.
Good point. The principal argument canvassed on behalf of the petitioner is that both the orders, one passed under Section 34 of the Act, as well as the Order 37, as well as the Section 37 order passed by the High Court, are non-speaking orders. Good point. We need to examine this aspect. Issue notice, give a particular date. Okay? In the meantime, the execution proceedings shall remain stayed. Good point.
Grateful to you.
Because may I request, if command consideration, Your Honor?
Yes.
There was two submissions. One, this scheme which the government has pronounced talks about 85% of the amount to be paid pending consideration and decision on the appeals. This scheme, my friend admits, is applicable. They did not give benefit to me only on the ground of pendency of Section 37. High Court has allowed the petition which we filed upon hearing that.
At this stage,
Let them
Mr.
deposit.
Pava, at this stage, Mr. Pava submitted that at least the petitioner should be directed to deposit 85% of the decretal amount. This aspect we shall look into on the returnable date.
Please. Can Lordship grant a fixed date if possible?
Fixed date.
Grateful.
Please, Sir Lordship.
My Lordship, this is a connected matter. My Lordship had issued notice in a connected matter on 6th October.
What is this matter?
My Lordship, this is the Karnataka state insurance matter, wherein the responsibility...
What is the subject matter?
This is with respect to the agricultural insurance company, wherein the responsibility was put on us as compared to the insurance company. Even after the term sheet was decided that the responsibility will be on them. Mr. Singhvi, the double AG, had argued the main matter.
Acha, that matter. You want us to tag it? Okay, tag it. Same relief. ये बहुत गरम हो गया.
Perhaps the impugned judgment gets everything right except sending the parties back to the trial court. It says the trial court's order is unreasoned. I buy a piece of land, my lords. I hand over the money. The gentleman does not register the sale deed. I take the matter to court. When the suit is proceeding at the trial court admittedly gives a rather strange order. The High Court is right on every point except then send us all back to the trial court for adjudication. Because here, my lords, as a buyer, my rights are not adjudicated upon. The original owners of the land, their rights are not adjudicated upon. In fact, this so-called seller gets away with everything, my lords, because he still got my money.
Come to para 9, Doctor.
Yes, my lords.
What is the High Court trying to convey?
My lords, I'll just read the paragraph, my lords. The judgment and degree is not. My lords, I bow down to this. We agree with this judge, with the reasoning of the High Court, that reasons have to be given by every court in this country. That is what a judgment must mean, that it is reasoned. But the trial court doesn't do that, my lords.
4 lines?
Yes, my lords, it is an abominable order. Abominable, my lords. It is unknown to law. But please send us back to another judge. It has been 10 years since. That gentleman must have retired. Send us back to another judge for adjudication. I cannot ask for anything more, my lords. I'm not trying to defend an abominable trial court order. I was shocked when I read it, my lords. But I have paid money. I am not allowed to register. I go to a court of law.
You are not allowed to
Yes, my lords.
register what?
The money I paid for the property, my lords, I think that is P11. P11.
So what is the status today?
My lords, the money has been paid. There's no registration that's happened.
Registration of the sale deed?
Of the sale deed. And annexure.
In your favor?
In my favor, my lords. I have no registrable sale deed right now, my lords.
So on what?
But the trial court, a separate judge in the same Krishnagiri recognizes that I have handed over the money. Please see, my lords, P11, page 83. Bottom of the page, 84, my lords. This is the decree. Now, this is a different judge who knows how to reason and write a judgment.
So today there are no proceedings pending.
My lords?
Today there are no proceedings.
There are no proceedings. And 114, if your lordship just goes to this page. Annexure P21, page.
So by the way,
yes.
This was a suit under Section 6 of the Specific Relief Act.
Yes, my lord.
Right?
Yes, my lords. And
Plaintiff says, I am in occupation, possession of the land. I have been dispossessed without due process of law.
My lords.
In that suit, the defendant doesn't appear.
Yes, my lords. The defendant.
Who is that defendant? The owner?
Yes, my lords. The owner of the
Just a minute.
Yes, my lord.
He is the owner. Since it didn't appear, the trial court says suit decreed.
My lords, the trial court.
Just a minute.
Yes.
Now, what is the transaction between you and the original defendant who didn't appear before the trial?
Please see, my lords, page 115. May I just take you to one?
What is the nature of the transaction?
I've paid 1,10,000 for land I believed I was going to get and registered. And admittedly, other than that, I have nothing else.
When a person files a suit under Section 6 of the Specific Relief Act,
my lord,
indisputably, he doesn't claim to be the owner of the land.
Yes.
He says, I am in possession.
Yes.
I could not have been dispossessed.
Yes, my lords.
And he comes to the court.
Lordship.
Now, if that original owner of the land wants to execute a sale deed in your favor, what is coming in his way?
My lords, this is what I'm not able to understand. Please see page
Then
115. Just
then
one
it's
page.
a dispute between you and the defendant. Why are you dragging this man in the litigation? He has succeeded.
No, my lords. In the trial court, my lords, please see. If I can just explain, 115 actually captures a different trial court, captures the problem here. This is the specific performance court. 115. Only
Specific performance suit is separate?
of the agreement to sell. Yes, my lords. That is.
You have instituted.
Yes, my lords. I have instituted.
And what is the status of that trial?
What is this? We have gotten the decree in our favor.
Did you implead this man as a party respondent in that suit?
In the trial court, my lords?
Huh?
No, my lords.
Why?
Because
Collusive suit.
may I just take you to 115, one page, my lords.
What is this man doing in the land? Cultivating.
It's agricultural land, my lords. It
What is the area of the land?
a little under an acre, my lords. It's not much. It's not a
इनको mediation में भेज दो, all three.
survey numbers. I can just tell.
All three.
5, 6.
To appear before the Supreme Court
Yes, my
Mediation
lord.
Center,
Grateful.
issue notice.
Grateful, my lords. I'm very grateful. I'm so grateful, my lords.
And one last question. When a suit is decreed, suit filed under section 6 is decreed.
My lord.
It's not a decree. It's not an appealable decree.
My lords, I follow your law.
No, you tell us. I don't know. My brother also doesn't know.
It is, my lords. It's an appealable.
Then how come a civil revision was filed?
Yes, my lords. My lords, but we didn't file it, my lords. They filed it. Yes.
We are asking.
Yes, yes, my lords. This litigation, all of it, my lords, the trial court judgment, the way this decree court rules, it's these parties need to sit together and resolve this issue, my lords.
Giri, if a suit is filed under section 6 of the specific relief act, saying that I have been dispossessed, he has to file it within 6 months of dispossession. And if it is allowed, that will not be a decree.
No, I think section 6 itself makes it clear that it is only revisable. It's revisable
then it's
because it is not appealable.
We had this doubt in our mind.
I think section 6
Got it.
says that.
Thank you.
No appeal shall lie.
Thank
from
you,
the
thank
order
you.
or decree passed in any suit instituted
Yes,
under
yes.
this section, nor shall any review lie.
Next matter.
Grateful, my lords. Very grateful.
Wonderful.
Please, your lordships, I am appearing for the appellant. My lords, here, on 2nd of August 2024, I am communicated that your resolution plan is being put to vote. Thereafter, after 4.5 months.
Mr. Mittal, come to para 6.
Yes.
Tell us what is wrong with this finding.
Lordships, what has happened in this matter?
Mr. Mittal,
Yes.
we request you to read para 6 and tell us what is the error in this finding.
Yes. The Committee of Creditors, in its commercial wisdom, has accepted the OTS and not approved the resolution plan submitted by the appellant. Appellant was only prospective resolution applicant, who had only right that his plan should be considered. The COC did not approve the plan. We are of the view that there is no ground to challenge the order impugned, which is order permitting the withdrawal of CRP on an OTS having been accepted.
Next matter.
No, lordships, may I say something?
No, absolutely no merit. Next matter. Yes.
My lords, in item 20, my lords, the well-reasoned order of the tribunal, my lords, granting me the interest from the date of deposit has been overturned by the High Court, relying upon a judgment which, my lord, dealt with an unamended provision, my lords.
Notice.
So obliged, my lord.
Very grateful, my lords.
Yes.
The council is appearing through VC.
Hmm?
The council is appearing through VC lordship, but I'm not able to see them. Patne, LC Patne.
Who is appearing in the matter?
Mr. LC Patne, my lord.
Huh?
Mr. LC Patne.
May it please your lordships.
Yes.
My lord, his challenge in this petition is to an order passed by the Honorable High Court of Madhya Pradesh, my lord, rejecting the plea of the petitioner that the redemption fine would qualify to be covered under the SVL DRS scheme 2019, my lord.
Come to para 7.
Lordship.
And make us understand what is the High Court trying to convey.
The High Court, Honorable High Court has paragraph 7, my lord.
First 3 lines.
Lordship. The Honorable High Court has said that as the SAS state has dismissed our appeal before 1/9/2019 and therefore the petitioner is not entitled to invoke the scheme itself, my lord. Whereas our claim was under areas category, my lord, not under the litigation category, my lord. There were 4 categories under which the petitioner could apply. The one declarant could make a declaration under SVL DRS 2019. First is litigation, second is arrears, third is investigation, audit or others, and fourth is, my lord, voluntary disclosure.
Right.
So our claim was being processed under arrears category, my lord.
Issue
I
notice.
request the lordship.
Issue notice. Next matter.
For the cabinet. My lord, it was our contention before the court that admittedly the matters have been settled as far back as 31st May 24. Your lordship kindly says,
There are disputes or not?
my lord, according to us, as between the parties, principal parties, no. The matter is settled. That is recorded.
You don't have any dispute with him?
Para 12 of the High Court order says.
May I tell your lordship? May I just indicate? What?
I only have 130 crores.
He says, I have no quarrel with you.
Yes.
You can give me my 130.
No, that is not the issue. I'm sorry, I'm not. There's a settlement deed.
Para 12.
The court, may I make myself? The
That will
settlement
be
deed.
looked into by the arbitral tribunal.
Your lordship keeps the
Next
points
matter.
open, my lord.
Section 17 has.
Heard the learned counsel appearing for the parties? Full point. No error, not to speak of any error of law, could be said to have been committed by the High Court in passing the impugned order. All contentions are kept open to be canvassed before the arbitrator. Next matter.
Great.
Really positive, my lord.
Argue. Come on.
Brief with the senior arguing consummers.
We are giving you a chance to argue. Argue the matter.
Ma'am, sir, my lordship, I can able to argue, but thing is the paper book, sir.
Start to karo.
My lordship is the petitioner.
You have come from Tamil Nadu?
Yes, Tamil Nadu, but my lordship.
Fine. You want a temple to be demolished?
Actually, yes, my lordship.
Since how long this temple is there?
My lordship, the temple originally not Porambok land.
67 years?
No, my lordship, the problem is the Tahsildar given a statement.
Why do you want the temple to be demolished?
My lordship, actually the original problem, there is beginning no temple.
Who are you?
That land neighbor, my lordship, the temple nearby residence. So
is the temple proving to be a nuisance to you?
My lordship, actually.
Why do you want a 60, 70 years old temple to be demolished? Make out a case, na?
My lordship,
the moment you say it is absolutely illegal something, we'll look into.
My lordship, humble request, little Passover, then.
Dismissed. Next matter.
My lordship, little Passover, my lordship.
No, sir. Next matter.
Okay.
Please. Lord, 7 years after, Lord, I filed the evidence affidavit. Lord, he files an application that, Lord, he has to cross-examine the witness. Lord, the DRT considers the application. And, Lord, he has come out with a very reasoned order, Lord.
This is nothing but all dilatory tactics.
See, I only want to cross-examine the witness. That's not what the High Court is.
What will you do by cross-examining?
Because there is a serious dispute regarding, Lord, many of the documents which have been filed or which have not been filed. And I have filed a proof affidavit. They can.
When is the cross-examination fixed? When is it fixed?
It was fixed. It was fixed today. They have sought an adjournment because stating that
you have to cross-examine.
I'll have to cross-examine. I'll do it today.
Who are you?
Lord, I am Lord the bank. Lord, 7 years after Lord, my evidence affidavit has been
to
filed.
be cross-examined.
Yes, that's all.
What is the name of that witness?
Arun
Lord,
George.
Lord,
Arun George.
Lord, this case pertains to 2003. Now, this person was not the branch manager at that time.
But he has filed the proof affidavit.
See. Arun George may be a successor in office over a period of time. This has something to do with transaction between a bank and you have obtained loan or something.
Not me.
Lord, he is one of the partners. Lord, other partners are contesting for 17
now,
years.
You must have adduced evidence by way of affidavit.
Please, my Lord.
Right?
Yes.
When did this happen? When was your affidavit?
2016, I filed the affidavit.
What transpired from 16 to 25?
Now he files the application, my lord.
No, no, what happened between
So that matter was, my lord, somehow or other, my lord, it was just, my lord.
You didn't take any steps?
No, my lord, I have been pursuing, my lord, throughout, my lord, because
Now,
it is
who
my.
is this Arun George? He's a branch manager?
He was a branch manager earlier.
Who is?
Whether he is a branch manager now.
Whoever has filed the affidavit,
Yes.
cross-examination will be only of that man.
Only on that.
Where is this man at present?
He must be there, my lord. It's up
Where
to
is
them
he?
to see.
He must be, my lord, in some
But
other
in
branch. in the
November, there
bank.
was a listing for cross-examining the witness. They said that they are challenging the order. Today there is a. Yesterday there was one. They again said they have filed an SLP.
But if your lordships read, my lord, DRT's order, my lord, DRT, and my lord, directly they come to the High Court from the DRT, my lord, DRT is, my lord, my lord, given a bypass.
Oh, why should the bank shy away from tendering the witness for cross-examination? my lord?
Your lordships, my lord, in a number of judgments have held that, my lord, direct to, my lord, High Court
The
is not.
Union Bank of India is aggrieved by the impugned order passed by the High Court of Kerala permitting the respondent number.
Lord, is the, my lord, bank's witness, my lord. Respondent number.
There is only one respondent here.
No.
No, my lord.
एक second.
He is fifth respondent otherwise, my lord.
एक second.
Fifth respondent to the OE.
Permitting the respondent before us. Who is the respondent?
Lord,
Fifth
he is
respondent
fifth
is the OE.
defendant in the suit, my lord. Other partners are
Permitting original defendant number 5 in the suit.
Correct.
Who is respondent number?
Who's the only sole respondent?
Sole respondent before us.
Yes.
To cross-examine Mr. Arun George, branch manager of the bank. First up.
Then branch manager.
The then branch manager of the bank. We take notice of the fact that Mr. Arun George had adduced his evidence in the form of examination in chief by way of affidavit way back in 2016. Almost 9 years have passed by, but till this date, the trial court has not been able to proceed further with the suit. This is something really very unfortunate. At one point of time, we were inclined to interfere. However, we would like to give one last opportunity to the sole respondent to complete the cross-examination of Mr. Arun George. Right? In any view of the matter, we want the trial court to complete the cross-examination of Mr. Arun George and pronounce the judgment within a period of 3 months from today without fail. The trial court is directed to report compliance of civil suit number.
It's a OA, my lord, before the DRT.
It's a DRT. Trial court, but DRT.
It's TA 32 of 2017.
DRT?
TA 32 of 2017 before the Debt Recovery Tribunal, Ernakulam 2, Roman 2.
Debt Recovery Tribunal, Ernakulam, State of Kerala is directed to dispose of
TA 32 of 2017.
TA 32 of
2017
without fail with judgment within a period of 3 months from today. The DRT shall report compliance of the disposal of TA so-and-so to this court.
Great.
Lord,
Grateful.
to your lordships, Lord, that the cross-examination will be completed in one day, Lord. Otherwise, Lord, they will, Lord, just.
But the DRT will take some time, na?
Please, Lord.
2 months kar do, 2 months kar do, chalo, 2 months.
Great.
The office report says, my lord, the plaintiffs have also filed SLP. Would your lordship take it up along with those SLPs, my lord? Would it be your lordship pleasure?
Keep it in the next week. In the meantime, agar koi connected matter hai, to tag kar do.
Diary 69577 of 25.
Okay.
May I just explain 3 facts before I get into this order, Milord? This is a CRP against a suit filed by respondent number 1. Milord, so I am one Anisa B's legal heir. This Anisa B was in possession of a property, Milord. This property was taken over by MADA for redevelopment. I was asked to move to an alternate accommodation. Anisa B moved to that alternate accommodation, Milords. After some time, she was served with a notice to surrender that and go back to the original accommodation from which she was shifted. She said somebody else is in occupancy of that. If I have to go back to my original premises, you have to have them vacated. The High Court passed an order, page 160 to 164, dated 8/7/2009, telling MADA, when MADA filed an affidavit saying, yes, we only dispossessed her, we asked her to go to a transit accommodation. Now, when she is trying to come back, somebody else is in occupation of those premises.
Who is that somebody?
The respondent number 1.
Who is respondent number 1?
They claim that they have been in occupancy of the premises. That's all true, but not through a sale deed. They say they paid some money to an erstwhile owner, and therefore they have been in accommodation. They have been in occupancy of the premises.
Where is this lady as on date?
Who, Milords? Because I am her granddaughter. I am Anisa B's granddaughter. So the High Court, it is pursuant to the High Court direction, Milords, where the MADA filed an affidavit saying, yes, we are the ones who took her away from these premises. We are now going to put her back after serving a notice on the occupant. Kindly see that order, page 160 to 164.
Mr. Parmeshwar.
Milords.
Kalavati Devi is the person who was occupying the premises.
Claims to have occupied the premises.
Whatever it be.
Very well.
You are not disputing the fact that MADA asked her to vacate that premises.
Yes, Milords.
She was put in some another premises.
No, the person who was put in other premises is me.
From where?
Anisa B, Milords. My grandmother was the tenancy holder in these premises. 1978, she was asked by MADA, you move, we will repair this building, reconstruct it. She moved. She moved to Bandra.
Who moved?
Anisa B. When she moved.
Your own property.
Look, this is tenanted premises.
Who is the landlord?
Whom did Anisa B take it from? Nazreen Khan. Nazreen Khan is the original landlord.
Then who is Kalavati Devi?
Now Kalavati now says she purchased the property from X and she has been in possession since 1995. Problem, I understand her plight.
And according to you,
Milords,
if Kalavati is the lawful owner of the premises, she is occupying since 1995. How come that you were in possession at some point of time?
1978, that's number 1. 2, I left that Bandra premises and came here when I was given a transit permit by the MADA itself. They told me vacate that.
It was a tenanted premise.
That is right, Milords.
After you vacated,
Milords, I didn't.
Locks were applied?
No, Milords, it was to be pulled down and constructed. That's why MADA said, we are going to give you a transit accommodation in Bandra. So you pull it down and we will reconstruct it. They served a notice saying, Milords, I understand her plight.
That lady.
Lady now wants to, if that lady now wants to say that she is the owner of the premises.
Where is this Syed Nazia Muhammad Iqbal residing as on date?
Today we are in that premises which is now sought to be vacated.
In what capacity?
As granddaughter of the original lessee. As granddaughter of the lessee. Put in possession pursuant to a High Court order by MADA. Kindly see that order, page 162, 164, and the affidavit that, kindly see this, Milords. You asked me to move, MADA asked me to move from A to B. My grandmother moved from A to B. MADA now says, A is ready, now vacate B. I say, I will not vacate B, my grandmother says, until you put me back from the place where you have displaced me. They file an affidavit, that's right. In the High Court, MADA files an affidavit saying A is occupied by somebody else. We will now put her back in A. Put her back in A. They put me back in A.
Now this X who's now claiming that I understand her plight, but her remedy is not a simplicitous suit under
You
section
can't
6.
throw out someone from the house like this and put you in possession.
No, we have been in possession since 2009, pursuant to the High Court.
Very doubtful. Very doubtful.
Let's kindly see the High Court order. Can I just show that, Your Lordship?
Very doubtful.
Can I just show two documents,
Very
Milords?
doubtful.
Kindly see my plight, Milords. Kindly see my plight. MADA asked me to move. MADA puts me in possession back pursuant to a High Court order. I go back. For 15 years, I am residing there. There is no doubt that today I am in possession. Last 15 years from 2009 when MADA put me in
What should we do with this lady, Kalavati Devi?
I have all my sympathies for her, but a remedy can't be a simplicitous suit for possession.
No, dismissed. Next matter.
Can I make an alternative suggestion
Yes.
if it appeals to Your Lordship?
Yes, you trash it out, interested. Next matter.
Because I can't trash it out because MADA has now walked away from. Can I just make it if it appeals to Your Lordship? Ask the MADA to put me in a different place because it's pursuant to a High Court order that MADA has put this.
We heard Mr. Parmeshwar, the learned senior counsel, appearing for the petitioner at length. There are highly disputed questions of fact involved in this litigation. Petitioner before us claims to be the granddaughter of the original lessee. She claims to be in possession of the subject premises past 15 years. On the other hand, the petitioner before the High Court claims that she was in possession of the subject premises and she was removed and she was asked by MADA to vacate the premises and shift to some other place. Full point. We are of the view that let the High Court look into the matter in details. We should not interfere at this stage. Next matter. If the petitioner herein wants to take up the issue with MADA, we permit the petitioner to file an appropriate representation in that regard. Next matter.
So this matter only reinforces what Your Lordship said in the morning. This matter only reinforces what Your Lordship said in the morning about redevelopment and Bombay.
Absolutely. Bombay, na?
Bombay.
Sorry to my brother. Huh?
What Your Lordship said in the morning.
Yes.
Great.
Bombay and Delhi. Bombay and Delhi.
My Lord, Mr. Darshan Patel is logged in through VC for the matter.
Please, Your Lordship, sir. I am appearing in this matter. The present petition is filed challenging the order passed by the Honorable Gujarat High Court, incorrectly interpreting the provisions of Section 149(1)(a) at par with section 149(1) small b of the Act. Now, if I may briefly state the sections, what the sections actually state. Lordships, if there is an escapement of more than 50 lakh rupees in the form of an asset or an expenditure or or from any entry or entries in the books of accounts, the revenue has the power to reopen the petitioner's case for 10 years, from 3 to 10 years. 1A restricts that when the escapement is less than 50 lakh rupees, as per section 149(1)(a), reopening can be done only on two conditions. That is, if the there is an escapement in the form of an asset or an expenditure. So far as the present case is concerned.
Mr. Chandrasekhar here.
Please, Your Lordship.
He's on his legs in another.
Issue notice. The learned counsel appearing for the petitioner shall furnish one set of her entire paper book to Mr. Chandrasekhar Bharti, the learned panel counsel who ordinarily appears for the revenue at the earliest.
Lordship, may I request?
We are concerned with interpretation of section 149(1) capital A of the Income Tax Act. Mr. Chandrasekhar shall take appropriate instructions in the matter and assist us on the next date of hearing. Notice de dena. Next matter.
Lordship, may I request for interim relief as per para 8?
Let Mr. Chandrasekhar appear and then we will look into it.
Grateful. Much obliged.
I'm in 52.
Your Lordships, in the similar matter, arising out of the common order, leave has been granted.
Tag kar do.
Oblige. Your Lordship.
Same order in 52 also.
Same order in 52.
My lords, in this matter, there are two connected matters pending before my lords against the same order.
Tag kar do.
Oblige, my lords. My lords, notice may be issued.
Notice kar do.
Oblige, my lords, the lower court records may be called for.
Okay, lower courts.
Grateful, my lords.
Your Lordship, item 30. We were the counsels representing the petitioner, my lords. My lords, we had submitted before the Honorable Court that we are not in contact. We made an attempt, various attempts to contact the petitioner, but no one is in our contact, and
What is this matter?
My lords, the petitioner died in 2015. My lords, this Honorable Court decided and convicted the petitioner accused on
Kailash Kumar.
My lords.
What type of proceedings have come up today?
Your Lordship, I am appearing for the state. Your Lordship, actually the proceedings have come on the basis of office report, Your Lordship. What was happened, Your Lordship?
What type of report?
Your Lordship, what was happened in this matter?
Kailash Kumar has passed away.
Your Lordship.
And any death certificate has been...
Yes, Your Lordship.
My lords,
So we
as per the
close
office report,
we close it?
My lords, the case stood abated in 2015. My lords, because he died in 2015, the case went on.
The proceedings are ordered to be closed in view of the office report. Next matter.
Oh, my lords, the settlement took place between my father and his brother, that's my uncle, and certain properties came to be exchanged, my lords. One of the co-sharers in the property was not happy with this exchange, which took place in 1980, my lords. And in 2009, after 19 years, my lords, he filed a suit asking for injunction alone, my lords. He admitted that I'm in possession since 40 years, my lords. And the first appeal has come to be dismissed only on the ground of delay, my lords.
Delay. What is that delay, ma'am?
My lords, the other co-sharers were not made a party, unfortunately. And this is a family dispute. We tried that it could be resolved from our end.
Inko mediation center पे तो notice.
My lords, execution proceedings be stayed in the meantime.
In the meantime, the execution proceedings shall remain stayed. The parties to this litigation are family members. They must appear before the Supreme Court Mediation Center and try to bring around an amicable settlement. Parties to appear on so and so date. Meantime, the execution proceedings shall remain stayed. Next matter.
I'm deeply obliged, my lords.
My lords, I am extremely sorry. I'm indisposed. I'm suffering from fever. Can my lords have it after 2 weeks, please?
It's all right. It's all right. Keep it after 2 weeks.
By the last order, my lords had asked for a meeting to be held between the parties. They called for the meeting on 29th.
And
So far, nothing has.
Amaras, I am very clear. I am a facilitator. I tried to help. I wrote to them categorically and informally, I believe, telephones call. They have not responded at all.
Who has not responded?
That person from whom she is claiming. There is one GDC and
Today,
one
I am
PNC.
claiming from them, in fact.
No, now, because she is not getting from them, she has roped me in. That's a different matter.
Who is that respondent?
If
That's
GDC, no, there are.
Huh?
GDCL, they're not a respondent because I'm only claiming from them. This was a situation of contract.
We'll work it out. We'll work it out.
Both are part. Just give me a minute. Brother. Your Lordship will have to then hear it if that is so. Just give me 2 minutes without opening the papers. There is a contract. The two subcontractors who have a contract with her are GDC and VNC. They are not parties here. They are not made parties. My learned friend, knowing that it is easier to sue me, sues me directly as an operational creditor. Now she's an operational creditor. Give me 2 minutes, but I'm going to suggest. It is not. She goes under IBC. She meaning her clients. When I say she, I mean her clients. They go under IBC. They are not remediless. They have a suit against GDC. They have a suit against VNCPL? No. They go in IBC against me. Today, Malas, your lordship will decide disputed questions of fact after 10 judgments which say, here there is a genuine dispute at every stage that a OC like her in section 9 cannot have Malas an IBC remedy. That's the long and short of it.
May I show my lords if that's the argument?
If your lordship were to implead them and bring them here, I have no problem. They will listen to your lordship's order, Malas, not to my letter of request.
Take down. Our order dated 3rd of November 2025 reads thus. We are informed that in pursuance of the order passed by this court referred to above, the parties before us did try to talk and bring around some settlement. However, they have not been successful so far.
Let them be impleaded.
We believe that in such circumstances, the presence of
Yes.
एक second. Presence of
You cannot prevent their being impleaded. Monies came from them.
Gannon Dunkerley
Impleading, who wants to catch them?
and Company Limited for short GDCL and measures Vijay Nirman Company Private Limited for short VNCPL is necessary. We permit the learned counsel appearing for the petitioner to join them as party respondents. Issue notice to the newly impeded respondents, returnable on so and so. We'll try to find a way.
Only one thing, Your Lordship, will record my statement. But I want to be very clear. I do not accept their side at all because they are fighting me also.
That we had recorded.
No, these two fellows, fellows.
Huh?
I am now making, not for today, later on, I am making it clear that these two fellows, GDC and VNCPL, I am in fact disputing them, already fighting one of them. So whatever they come and say, whether they support me or against me, they, Your Lordship, and not saying that I am supporting them in any manner.
At this stage, Dr. Singhvi, the learned senior counsel, appearing for the respondent,
hearing that now,
submitted that this client has nothing to do with the two newly impleaded respondents. Full point. We shall look into the matter on the next date.
But my basic objection remains in an IBC section 9. Your Lordship may bang their heads together and get some solution. I'm very happy. But this will not lie against
My lords,
me.
I
With a dispute. There's a dispute, section 9 has 5 judgments barring it. That's all I'm saying.
Let those two.
If it works out, brother, I'm quite happy.
Fine. Next matter.
My lords.
Please, your lordships. My lord, this is the third show cause notice. The first two show cause notice, they concede the classification in favor of revenue. They go to the settlement commission and they pay the duty in the revised classification. Now, third show cause notice, they don't go to settlement commission and they contest and the tribunal allows it. I will show exactly the ditto proceedings, my lord. Please see the first proceeding.
What is, sorry, एक minute.
In order to buy peace, I go to settlement commission.
Let me show something very, very startling about what the tribunal has done.
Is it?
Well, there are 3 show cause notices.
What happened here?
Yes. Well, there are 3 show cause notices. Reclassifying, they have called it as components of TV, whereas we have said it's a CKD or a semi-knockdown condition pack of a television.
Something to do with
classification. Lordship may issue notice, my lord.
Well, your lordship will see the finding.
But let us hear it.
Obligatory.
Notice. You will waive notice?
Yes, please.
Mr. So-and-so, the learned counsel waives service of notice for and on behalf of the respondent SSC. Next matter.
Obligatory.
Lord's pass.
Please, my lord. My lord, what happened in State Bar Council of Uttar Pradesh? Now they have charging 2,500 rupees for the purpose of interview. If any advocate registered.
What type of interview?
My lord, for the registration of the enrollment.
Providing.
Yes, my lord.
UP Bar Council?
Yes, my lord. This is the.
And they generally take 6 months around.
Otherwise, they generally take
And
6 months.
Thereafter, they provide their notice.
Your Lordship, we had issued a resolution and a direction to all state bar councils that they should not only comply with the original order but also pointed your Lordship.
My lord, this is the.
That is on record as filed by the West Bengal State Bar Council at page 10. Kindly have our resolution dated 4th November 2025, page 10 of the State Bar Council's affidavit. We had made it clear that your Lordships have indicated any violation will amount to contempt.
And my lord.
Take down. Who is this Priyadarshini Saha?
Yes, my lord. I am appearing item number 35, my lord. That is contempt petition, my lord. What?
So you are appearing in which matter?
35.1, my lord. That is writ petition.
Who are you?
I am petitioner, your lordship.
It's a fresh petition.
This is a fresh petition, but your lordship has issued notice. Earlier issued notice. Thereafter, they have filed counter.
Just a minute. Your contempt is against whom?
My lord, state of West Bengal, my lord.
What are they doing?
My lord, kindly see page number 14. They have filed compliance report, my lord. After the issuing of the notification by the Bar Council of India.
Why there is a red dot on 35.1? Has someone circulated a letter?
Yes, my lord.
Who has circulated the letter?
So the respondent council for the Bar Council of UP had circulated a letter for a.
You have started taking interviews of those candidates seeking enrollment.
Your Lordship,
What interview? What do you ask them in interview?
I'm the proxy counsel in this matter. The main counsel is not.
35.1 में पहले order लीजिए. The learned counsel appearing for the petitioner has brought something very shocking to our notice. According to the petitioner, the Uttar Pradesh Bar, what is it called?
State Bar Council of Uttar Pradesh.
According to him, the Bar Council of Uttar Pradesh has evolved a unique method to overcome the directions issued by this court in the main judgment rendered in the case of Gaurav Kumar so-and-so, by taking interviews, oral interviews of the candidates seeking enrollment. For the purpose of appearing in the oral interviews, they are charging rupees 2,500 from each candidate. Right? Okay. Issue notice. On the next date of hearing, we want the affidavit of the Bar Council of Uttar Pradesh on record. Fine? Okay. What's your good name, sir?
Akash Singh.
So and so waive service of notice for and on behalf of the Bar Council of Uttar Pradesh. Now, what is your matter?
Can we see the page number 14? They have filed compliance report, my lord. First, at annexure P2, my lord, BCI issued a notification to compliance with the order of this honorable court. After that, my lord, at annexure PR4.
No, which direction they are not complying with?
My lord, thereafter they issued state of West Bengal like we are complying with the honorable Supreme Court direction. My lord, I am just providing this fee memo, my lord. Kindly see. They have issued the notification on 7th November 2025 and someone sent me.
उसमें वो 35.1 में एक line add कीजिए. In the meantime, we direct the Bar Council of India to look into this matter and take up the issue with the state, what is it called? With the Bar Council of Uttar Pradesh.
Please, Your Lordship, we'll do that.
What is this?
My lord, someone has paid.
Someone means.
Lordship, I am appearing for the Bar Council, Lordship. We are not collecting. Lordship, we are not collecting anything.
There, my lord, before the Lordship.
This 4,000 has been collected towards what?
My lord,
Lordship.
The contempt note.
Towards what?
My lord, for the development fee and library fee, my lord. Kindly see, for which we have challenged, we have filed this contempt petition, my lord. And my lord has issued notice to state of.
Mr. Chetarji, how are you concerned with library?
Lordship, we are not collecting anything after your Lordship's order. We have withdrawn all these things.
Mr.
I don't know.
Vishal.
I don't, we have given an affidavit, we have
The learned
tendered
counsel
an
has appeared on
unconditional
behalf of the
apology.
Bar Council of West Bengal.
Library development and building fund fee.
We have stopped it now.
We request Mr. Chatterjee to take appropriate instructions in the matter and revert on the next date of hearing.
Lordship, let my learned friend give those documents in an affidavit, because we don't know what is the source of this document now and what is the date of this document.
Press applicant.
If it is found to be incorrect, we will take
Yes.
him to task. There's no
Yes.
doubt about it.
Yes, Lordship.
Next matter.
Grateful.
Sorry to intervene, Your Lordship. Actually, in this matter, Bar Council MP is trying to extort 5,000 rupees and NOC transfer. Lordship.
Who are you?
Sir, I am Pushpendra Sharma. I am an enrolled advocate since 2020.
Is any petition of yours today on
No,
board?
sir, I am just asking for liberty to file an petition.
Go and file it.
Lordship.
On an identical issue, in my own case for a different assessment, I am already before your honors.
Tag it.
On an similar interim orders.
Tag it.
Grateful, Your Honor.
Follow.
Your Honor, would similar interim orders also apply to the same? I'm grateful.
Good.
My lords.
There's a letter.
Yes.
Letter.
I'm seeking a Passover. Yeah.
H in it.
Let me kindly keep it in the next week.
We'll give you some date.
Obligement.
May it please?
Yes.
But as per the last order, my lords, we have paid entire amount what is due to the wife. This is cases arising out of the maintenance for the wife and children, my lords. The children.
Let us see the last order. What is the date of the last order?
It's 27 time.
Lord, I'm sorry. I seriously object to the compliance affidavit, Your Lordship. 4,55,000 is still pending.
4,50,000.
We have deposited 7,35,000 because first time I'm hearing from his side, other side. We can verify it, my lords. We can verify.
No, Your Lordship.
For whom?
My Lord, there is a complaints affidavit stating that two amount, Your Lordship, they are saying 1,10,000 which I withdrawn from our joint account in 2020 before 4 months of filing of the petition. That should be treated as maintenance. The other amount 3,50,000 which I got as my insurance amount, my life insurance amount.
दिखाइए. Compliance affidavit दिखाइए.
Compliance affidavit, Your Lordship.
Where is the compliance affidavit?
It's filed, my lords. It's
filed on 3/12.
3/12 minutes. I'm sorry. It's
B.
3/12 minutes.
Huh?
3/12.
3/12.
2/12. Affidavit date is 2/12/25. It's filed on 3/12.
Page number 2 of the affidavit.
We have given a.
You appear for whom, Mr. Hamid?
I am for the respondent, Your Lordship. Respondent, by first respondent.
Paragraph.
Surya.
Yes, ma'am.
And who are the three petitioners before us?
Petitioner is the husband.
This is item number
39.
39. Manoj Millets. Through power of attorney.
So, who is Dr. Manoj?
Manoj is the husband, Millets.
And who is Professor Soma Sikharanunni?
Father of Manoj, because he is abroad.
Who is Prasanna Kumari?
Mother of the my mother-in-law.
Understood.
Let's kindly see paragraph 3 with the complaints regarding if he is disputing paragraph 3. What we have said is the submitted as per the order 21/7/23 passed by the learned additional session judge Ernakulam. The petitioner is paying the maintenance 50,000 per month, and that as on today the petitioner has paid totally an amount of 7,50,000 rupees. The breakup is given, my lords, thereafter.
So,
and I am disputing, my lord, 7/12/2020 the date and 22/8/2022. Two dates are shown there. 7/12/2020 is an amount which I withdrawn in December 2020, my lord, before filing of 4 months of filing of my MC from our joint account, which had an
separately the time.
then 2022 date. That is my insurance amount.
This amount which you have deposited is towards what? Arrears?
My arrears of maintenance. There are issue. What is the issue, my lords? Now arrears is not though I challenged it.
Marital life of how many years?
My lords, it's a
2007 married.
7 marriage, and children grown up. They are studying abroad. I'm taking care of them. One of the person is staying in the board school.
So why not dissolve the marriage?
We will have to, my lords, that either she wants to live with or we have to give it up, my lords. That's the only way we can do it. What happened, my lords, there is further litigation. I'm just giving a 1 minute. What she did is after the maintenance order, she has to be provided after an alternative accommodation.
Mr. Hamid,
Yes,
this
your lord.
seems to be a case of a dead marriage.
Yes, my lords.
My lord, my client says that, my lord, she still wants to stay with her husband. He, for last 2 years, my lord, she is
ready
now
to accept her.
Let's, we can take a call, my lords, as today, since the offer has come, she wants to stay.
The learned counsel appearing for the petitioners submitted that
Mediation, my lords.
affidavit of compliance has been filed. Affidavit of compliance of the order dated 27/10/2024 has been filed. According to him, his client has deposited a total sum of rupees 7 lakh.
7 lakh, my lords, paid. You also may say paid. 7,50,000.
Has paid.
7 lakh.
His client has paid 7 lakh, an amount of 7,50,000.
which I dispute. 4,54,000 is still pending. 4,64,000.
On the other hand, Mr. Manas P. Hamid, the learned counsel appearing for the respondent wife, would submit that the husband has yet to pay an amount of rupees 4 lakh and
64,000.
64,000.
876.
876. Full point. The learned counsel appearing for the petitioners shall take instructions in this regard. At the same time, we believe that the parties should once sit together and try to bring around some amicable settlement.
Obliged.
For this purpose, we direct the parties to appear before the Supreme Court Mediation Center on so-and-so date. We request the center to appoint a senior mediator. Okay? Fine.
First hearing may be easy, my lord, because he is in abroad, he has to come, then it can be done, my lord. Sir.
Online.
Online. I'm very grateful.
Obliged.
Grateful.
Yes. Letter.
Letter has been sent later. Grateful. Would I appear for the respondents in the matter?
What is this contempt about?
Can I get a password?
What is this contempt?
Lord,
Contempt of what?
The contempt of it is order dated 16th September 2011.
My goodness. What was parties
Leave
are
was-
directed
leave
to
was-
maintain status quo?
Leave was granted in 2014 by this honorable court.
Ah.
And the stay order was there.
Ah.
And when the leave was granted, it was ordered that the stay order will continue. The status quo will continue.
So what have they done?
Now the Gram Panchayat went to the collector.
Hmm.
They filed a eviction suit. So collector has now issued a notice to us. They have issued a show cause notice. So that is the contempt of order dated 16 September 2011. And
you appear for?
My lord, I appear for the contemners, my lord, alleged contemners.
What is your case?
Yes, my lord. My case is, my lord, that this was in fact a mistake, my lord, for the reason of an oversight.
Beg your pardon?
My lord, this was a mistake, my lord, which happened because of an oversight. In fact, my lord, the proceedings were initiated under Section 7, but as soon as they were brought to our knowledge that there was a stay order, on 8th of July 2025,
The collector had already adjourned the proceedings, my lord, sine die.
No,
and I have the order.
not adjourn it, drop them.
We will drop them.
Proceedings are to be dropped.
We'll drop them, my lord.
Otherwise, we will hold you guilty of contempt.
We'll drop them, my lord.
Take down. The contempt petitioners the petitioners, according to the petitioners, the respondent, only one respondent?
There are two respondents.
The respondents are in contempt of the order passed by this court dated 18/7/2014. The order dated 18/7/2014 reads thus, quote that order. According to the petitioners, despite there being a specific order passed by this court, the respondent number 2, na?
Yes, ma'am. It would be 2.
Huh?
Collector, yes, respondent number 2.
The respondent number 2. Who is this respondent number 2?
He is a collector, Panchayat Land DDPO Patiala, Amandeep Kaur.
The respondent number 2, so and so, thought fit to institute proceedings against the petitioners herein under
Section 7.
Section 7 of
Eviction suit of Punjab Common Land Act.
So and so, right? The learned counsel appearing for, you appear for?
Well, for both 1 and 2.
The learned counsel appearing for the respondents made a statement that the proceedings were instituted inadvertently, being oblivious of the interim order passed by this court. Full point. According to the learned counsel, no sooner the respondents came to know about the interim order, the proceedings instituted against the petitioners have been adjourned sine die. Full point. In the first instance, no proceedings could have been instituted, and therefore, adjourning the matter sine die is not going to serve any purpose. For the present, the respondents shall drop the proceedings, subject to the final outcome of the main matter. Fine? Okay. With the aforesaid, the petition stands disposed of.
I'm obliged. Look, for the reason that we could only file a wakalatnama yesterday.
Yes, no
allow us to
problem.
give appearance. I'm obliged.
Please, Manoj. Manoj, this is the matter to Erica. Detention since 16/5/2025 minutes on the last.
We'll take it up. This has been heard substantially with Justice Vishwanathan, na?
Yeah, Manoj,
Same matter.
Manoj was right. Manoj, this is the, there was a direction for the affidavit that's filed.
Keep it on Wednesday.
Manoj, may I request that it can be taken up on Monday, Manoj? My reckonet would be completely.
This Monday?
This Monday, Manoj.
Monday, we will not be in the same combination. Then put it on Friday. Next Friday.
Manoj, can I just pass it over? I'll just take the instruction because I may not be able to assist Manoj in that case.
Pardon?
Manoj, I'll just, Manoj, kindly keep it on Friday.
Okay.
Very good. Manoj, can I request from the top of the board? The reason is that.
Top of the board. You have taken instructions, na, Mr. Chandrasekhar? Taken instructions.
I'm not filing a reply affidavit.
It's all right. We'll look into the legal provisions.
Manoj, the document which I submitted along with that affidavit, this document submitted in the July 2025.
It's all right. No problem.
Everything fabricated. That's my submission to your note.
Okay.
Very good.
Please, my lord. 1612 days delay, 4 years, 9 months. That has been. Item 44, my lord.
What happened?
Honorable High Court condones.
41.
44.
40. Yes, Ms. Pati, you were to convince us
My lords,
on delay.
Yes, my lords. If your lordships will kindly have the counter affidavit.
Ah.
My lords, page 2 of the counter, we have culled out the entire sequence, my lords, from the passing of the order to the appeal, my lords.
Was it shown to the High Court?
No.
My lords, we had pleaded
Keep your mouth shut.
not in so much of length, but we had pleaded that because of COVID, the delay has happened. But here we have explained at length, my lord.
Fine. We are setting aside this order, remitting the matter to the High Court
Please,
to hear it afresh,
please, my lords.
and whatever explanation you have to offer, to put it to the High Court. We expect the High Court to pass an appropriate order.
Please, my lords.
Take down. Leave granted. This appeal arises from the order passed by the High Court of Madhya Pradesh dated 1/9/2025 in IA number 6849 of 2024, filed in first appeal number 1515 of 2024, by which the IA preferred by the state of Madhya Pradesh, seeking condonation of delay of 1612 days in preferring the first appeal, came to be allowed, and thereby the delay was condoned. Good point. The petitioner, decree holder,
Please.
being dissatisfied with the impugned order passed by the High Court, is here before us with the present appeal. Full point. We heard Mr.
Dushyant Parashar,
the learned counsel appearing for the petitioner, and Ms. Aishwarya Bhati, the learned ASG, appearing for the state of Madhya Pradesh. All that we can say is that the High Court condoned delay of 1612 days on mere asking, without discussing in any manner what explanation was offered by the state for this delay. First of all, the law, insofar as condoning delay is concerned, is now well settled. In the recent past, this court has delivered judgments explaining in what manner the sufficient cause has to be looked into and the plea for condonation is to be decided. According to Ms. Bhati, the delay occurred because of COVID-19. However, we do not find a word in the impugned order of the High Court.
That's right.
In such circumstances referred to above, we set aside this order, we set aside the impugned order and remit the matter to the High Court for fresh consideration of IA number 6849 of 2024. The High Court shall hear the parties once again and pass a fresh order in accordance with law. With the aforesaid, this petition stands disposed of.
My lords, may I seek one more liberty? Lordship may permit us to file a better affidavit or an additional affidavit.
If the state wants to file an additional affidavit explaining the sufficient cause for the delay, it may do so.
I'm very grateful, my lords.
Grateful, Madam. Deeply obliged.
May I please, my lord?
Sure.
मुझे याद दिलाना ये ऑर्डर में 4 जजमेंट्स when you bring it to me.
My lords had circulated a letter, but they returned my letter for counter affidavit. I need to place certain maps on record for the thing. That's why I think the petition.
Your Lordship, this matter essentification of a 3rd April 1995 order June 2025 had in its order stated that we need to, while passing an order, the Apex Code order dated 3rd April 1995 comes into the way. So had asked us to seek clarification. Hence, we are before this court. Your Lordship, page number 67. All the pleadings are completed. The contesting respondents who are the PIL petitioners, petitioner number 1 and 3 had sought time, but however, the entire pleadings and it's for the limited purpose of decoding this particular order at page number 67. Now, Your Lordship, the playground, this essentially is about the area of the playground. Now, as per the 1991 DP, it said 5250. As per the DCPR 2034, it is 5250. As per the city survey, it's 5250. Everywhere it is 5250. Yes, Your
Couldn't
Lordship.
understand a word. Where are you? At your residence?
No, Your Lordship, I'm in Bombay. Your Lordship, apologies, I could not come because of the
Come
flight.
back to Delhi, appear in person and make us understand.
Yes, Your Lordship.
We'll file our counters, Lord, also.
Okay. Chalo,
Your
next.
Lordship, a short date may be given. Your Lordship, also one particular thing I'm not able to construct at all right now. So at least I may be permitted to construct in the balance portion. There is only a stay as regards 6,000. Let me start construction on the balance, or a short date may be given.
You come back from Bombay first. It will take at least 4 to 5 days if you want to fly. Better board a train overnight and then come. Okay? Acha.
Yes, Your Lordship. Any short date may be given because this meetings are all completed, Your Lordship.
And why the service is
Your
incomplete?
Lordship, our RNP may be called for, Your Lordship. Because it's only about a clarification. The authorities, that is the BMC and the SRA, are with us with
Fine,
regards
fine.
to this.
Okay, okay.
Lord,
fine.
permission to file reply.
Okay, chal. Next matter.
Obliged. Lord, they say permission to file reply. Otherwise, they won't terms. Grateful. First time.
When in 46, Willows, Your Lordship, so pleased to issue short notice as well as Dusty. The service is complete now.
Exactly.
And this, I might just remind the court what this is about. This is in respect of a petrol bunk. And there's a huge infrastructure.
I got it. That petrol bunk.
Yeah, there's a petrol bunk for which we have decided to say. So I don't know if the...
It's I appear for respondent 4, Malaj. IOCL, it's my... The distributor is respondent 1, Malaj. I don't know if he's appearing.
Your Lordship, I'm appearing for respondent number 1. Your Lordships, my instructions are, Your Lordships, that we are in contact with the respondent number 4 for alternate premises and also for shifting. And there is, in the meantime, Your Lordship, there is also a dispute with the company, petitioner company, Your Lordships, because according to us, this particular portion on which the retail outlet is being functioning was not initially part of the sale transaction. They had sold the other properties, adjoining properties. There is some issue regarding the consideration. Maybe they had not agreed with it, Your Lordship. That civil issue is pending. Independent of that, Your Lordships, today what they're saying is that...
Their case is that permitting this petrol bunk to operate is a potential threat.
Yes.
You know?
Yes, Your Lordship.
That's the main concern.
That area is taken over, Your Lordship.
Now, whatever may be the dispute insofar as that agreement of sale is concerned, that can be resolved. But why are you putting them to difficulty?
Because I am a retail outlet, Lordship. The IOC, Lordship, it is the infrastructure in the retail outlet, Lordship.
So exactly what relief are you seeking, Mr.
No, we are simply, my learned friend who's the petrol pump operator has identified a specific other area down the road. IOCL is also here. They are ready and willing to shift. So some period may be given for...
So who is coming in the way of shifting?
Respondent 4, the owner is coming in the way because he says there's a commercial dispute. Not 4, sorry, the respondent 1 who's the original.
Where is he?
Here,
I'm respondent 1, Your Lordship.
The writ petitioner is coming in the way, but now if he says he's shifting, I'm very happy.
Okay.
Whatever commercials are there, we will immediately sort out.
So by what time will you shift?
Your Lordship, IOCL has to facilitate my shifting, your lordship, because that
In a way, he is right because
The IOCL, should I just?
it's not just applying locks
Yes.
and
Should
walking out.
should I just indicate the problem?
Take 1 minute.
Yeah.
Has IOCL identified any new lands?
As per Malaj, we got the notice Malaj 2 days back, Malaj. But Malaj, as per the record, Malaj, they have offered an alternate site.
Yes.
He himself has offered an alternate site. We are agreeable. Obviously, we don't have any difficulty because it's a big power project. That's one Malaj. But Malaj, as regards the timeline in which this would shift, for that Malaj, I may be allowed to Malaj take instructions. Malaj can pass it over, or Malaj can have it Monday. Malaj, because regarding this,
Just a minute. Take down. Today, when the matter was taken up for further hearing, Mr.
Chandrasekhar.
Mr. Chandrasekhar, the learned counsel, appearing for the retail petrol outlet.
dealer.
Sorry, appearing for the retail, what do you say?
Dealer.
Retail
outlet dealer. Malaj.
Retail outlet dealer very fairly submitted that his client has decided to shift the retail outlet to some other place. Full point. The learned, what is your name?
Malaj Shashwat Goyal Malaj.
Mr. Shashwat Goyal. The learned counsel appearing for the Indian Oil Corporation Limited, upon instructions, submitted that they would facilitate shifting of the subject retail outlet at the earliest. Full point. One thing is certain, that a decision has been taken that the outlet has to be now shifted. It's only a matter of working out the modalities of shifting it. We grant a week's time to the respondent number 1, as well as to IOCL to work it out and see to it that the outlet is dismantled and shifted to the place, the new place which has been identified. Okay?
Yeah.
Put it up on 14th of December.
Grateful.
Top of the board.
Grateful.
Now don't drag this litigation. See, something goes wrong, you are doomed.
Yes, it comes on me, because
It's a huge project.
I hold-
God forbid if a blast takes place or something, hundreds of those laborers may suffer. It could be a case of a very serious casualties.
Would your lordships just record that other contentions regarding compensation may have kept open, your lordship, because
But they are nothing, this litigation has nothing to do with compensation. And you will pay compensation from whom? From whom?
your lordships, there is an agreement to sell with the petitioner company, your lordship.
Have we said anything about the agreement to sell? Your agreement is with Mr. Diwan's client, na? So Mr. Diwan has decided to purchase it.
Yes.
You are going to sell it.
Yes.
Sell what?
The plot on which I am running the retail outlet.
That you are the lawful owner of the plot.
Yes, your lordship.
The retail outlet is of the IOC.
Yes, the licensee.
Have you instituted any suit for specific performance?
No, your lordships. There is a suit for injunction here.
You don't want to buy, Mr. Diwan?
No, we want to buy. Manoj.
हाँ तो चलो लेके चलो जाओ.
We'll buy it. Let the shifting take place. and
पहले
we'll buy it.
shift करो.
It's that
पहले
litigation only that's pending.
पहले shift करो.
Please.
He will immediately pay you, execute the sale deed and
Correct.
finished.
Great.
Next.
Great.
Yes,
May I please, your lordships? My lord, on the 31st of October, your lordships had directed the contemners, my lord, to file an affidavit stating that I have joined. And my lord, a statement was made by the contemner that I had indeed joined. The affidavit was filed. All the documents relied upon, my lord, in the affidavit.
Just start afresh. Can't recollect anything. Who are you?
My lord, I am, my lord, I am the petitioner. This is coming up for the first time before my lords.
First time?
First time.
What is this matter about?
I have a list of dates. May I circulate the list of dates?
1 second.
Lord, I am for the, my lord, petitioner. I think I should be permitted to start.
But anyway, in my lord, friends.
There was some contempt petition.
That's right. This is a contempt petition, my lord. I was directed to be reinstated. I was supposed to have, my lord,
Reinstated in what?
as in my position in the,
You were holding what position?
junior engineer in the border roads task force. Border roads task force.
Now, what went wrong? Why have you been terminated?
My lord, my lord, I was terminated. Then the termination was set aside by the single judge, confirmed by the High Court. Then, my lord, after the High Court set aside the termination.
There seems to be some direction against you to reinstate him.
Yes, there was.
Have you? You reinstated.
The dispute is what has arisen, and I don't know.
Why are you aggrieved by this order?
Because I have not been reinstated. Till today, I have not been reinstated.
Instead, you are.
I have not been allowed to join.
Affidavit says he has been.
Till today, I have not been allowed to join.
Mr. Vikramajit Banerjee, the learned ASG, has appeared on behalf of the respondent numbers.
One and
Huh?
one and well, let's be one, two, defense secretary also.
For the respondents.
Respondents. All
According to him, the petitioner has been reinstated in service.
and then dismissed.
Oh, then you dismissed him.
Yes, because that was the leave which was given to us, saying you reinstate him and then proceed.
The idea in reinstating him
Well, that was the
and then dismissing him.
that was the leave which was given. The court says we quash your dismissal because it was not served on him. So now you reinstate him and then you continue with your proceedings. And in terms of the proceedings, whatever.
So you have challenged the dismissal order now?
Has
My
not
lord,
been
what has happened is on 7th of June.
But today, rightly, wrongly, legally, illegally, there is an order of dismissal staring in your face.
I was not even, my lord, permitted to join. So without being permitted to join, how can he dismiss me? My lord, on the 7th of June.
What are the allegations against you? What are the charges against you?
My lord, absent without leave. That, my lord, I succeeded, my lord, right till the division bench.
What are the imputations? What are the imputations against you?
My lord, my grandmother was ill. I had, my lord, taken more time. There were 3 extensions, etc. My lord, that chapter is over. Then the contempt or court, my lord, on the 7th of June 2023, directed them to reinstate me and, my lord, allow me to join the very next day, which was 8th of June. They did not allow me to join. My lord, after all these documents that they have shown, they are showing.
Reply?
We filed a reply. He is fine. Malad, what has happened? Let me put it this way.
Lord,
We
you may
said
put it
that
on
we
a-
disclosed documents. He says he filed a counter to the documents we disclosed as proof, where he says I've joined.
File your reply.
Yes,
We filed.
Serve a copy to him.
We've done.
If you want to file any rejoinder, file.
I'm obliged, my lord, because
filed it.
in my respectful submission, my lord,
we
they
filed
have
it.
filed a
It's on record.
false
What is
affidavit
on
before, my lord, the highest court.
On record.
What is on record?
Our reply.
देखिए लाइए record reply दिखाइए.
Malad, in pursuant to which, Malad, may I submit, Malad? The court asked me to disclose proof of his joining. I disclosed proof of
Let
his
us see
joining.
what you have said.
Contempt reply.
Yes, yes.
My learned friend's client has filed a reply to my documents saying that he did not join. We say he joined on the 8th. He says I joined on the 9th. Well, we'll see his latest affidavit which he has filed. Well, we'll.
Now, What is the original order of the High Court of 2023?
2023. Well, there are a number of them. The impugned order, Malaj.
Why he had to go for contempt?
Well, it's because, Malaj, what had happened is the High Court quashed that order.
Which order?
Of my dismissal on the ground that it was not served on.
Right.
Then they asked us a limited amount of time in which to complete.
There was a departmental inquiry initiated?
Yes, yes.
He participated in the inquiry?
At that point of time, it was not served on him. It was in his absence. The court set it aside.
The High Court?
The High Court set it, division bench set it aside.
And what did the High Court say? Reinstate him in
Reinstate him. But now, after that, you conduct your inquiry. So we then reinstate him and conduct the inquiry and dismiss him. His argument is, what I sort of get from what he's saying, because he shifts his stance a number of times. He says he wasn't reinstated. So how could the proceedings be carried against him? But Malaj, we have disclosed, he has owned his latest affidavit. Lordship will see his latest affidavit, where he said he joined.
This order of reinstatement is 8th of June 2023?
Yes, he says he joined on the 9th.
One minute. And you dismissed him on which date?
Well, that was dismissed long time back.
No, later.
You said the second dismissal. 2nd January 2024.
That 2nd January 2024 order was never made a subject matter of challenge?
No.
Fine. So this contempt, the order which has been passed by the High Court in contempt jurisdiction, is of the first order.
Yes. What the High Court does in the first order, the impugned order, it says that we're extending time to you for complete the internal inquiry.
What do you propose to do now in the wake of this dismissal
Lord,
order?
I'll just to give your lordship the background. Your lordship needs to take note of two orders. My lord, first order of the High Court in contempt was passed on 7th of June 2023, where the High Court, my lord, directed them to, my lord, permit the petitioner to join the concerned office by tomorrow. This is 7th of June 23. Thereafter, my lord, in the reply that my learned friend is saying, he, my lord, files, my lord, documents which has a so-called reinstatement order, etc., which are dated June.
Your client,
then the High Court, my lord, takes cognizance of all this, passes an order. May I place that order, my lord?
Your client remained absent for how long?
No, that was not during this time. That was, my lord, in 2011.
Report back. Did not report back.
My lord, may I just...
But on the very same ground,
yes,
today he has been dismissed.
He could not have been because he was not permitted to join in the first place, which, my lord, all these documents are, my lord, false, according to me, my lord. The statement is false that I was permitted to join. And I joined because all these documents are dated June 23. Thereafter, my lord, in September 23, I'll just read one order of the contempt court of the High Court Division Bench, my lord. Lordship may kindly come to page 68 just for a moment. I'll just read this one order. Your lordship will, my lord, of the SLP paperbook, everything will be very clear. SLP paperbook, my lord, page 68. Contempt court order, division bench. Para 4 onwards, my lord, straight away. In fact, let me read this, my lord, order, my lord. White order dated 14/1/2015 issued by the Chief Engineer Prodex Sampark GREF. Petitioner herein came to be removed from service. The entire period of overstay leave
Now
was...
you want us to do what?
My lord, I want your lordship to direct that my lord, I be permitted to join. In spite of several orders of the High Court, several of your lordship's order, till today I have not been allowed to join.
How do we take care of that order of dismissal?
My lord, order of dismissal, my lord, was set aside.
Second dismissal.
How could I be dismissed without being reinstated, my lord, and joining service?
Someone will have to look into that order now.
But, my lord,
to challenge that order.
But I am, my lord, on the first part of the order of the High Court, which says that I must be permitted to join. I am only on that, my lord. I must be permitted to join. I have not been permitted to join.
Have you read this order?
Yes, my lord. Kindly see, my lord, this is reinstatement order. This is dated, my lord, 8 June 20.
His signature.
Wait a minute.
Lordship may kindly see, my
You
lord.
have read the affidavit?
Yes, my lord.
Come to para 3.
Yes, my lord.
He was serving as what?
Reinstatement, junior engineer, E&M,
What is his age?
49.
What is the superannuation age?
60? You tell it. 2034 is the retirement age. You tell, please instruct him.
2034. Fine. Now, once again, we are asking you, this must be the third or fourth time. What was that period of time that he remained absent?
Below 2011.
3 months.
3 months.
3 months.
2011 onwards.
He did.
1/8/2011.
He didn't obtain any sanction. He didn't get the leave.
Lord, he got leave. Thereafter, he got stuck because of his grandmother's illness initially. And thereafter, my lord, various other circumstances.
Now, what we understand is, rightly, wrongly, what you need to do is challenge the fresh order of dismissal.
But, my lord, before that, the order of the High Court was what? To, my lord, permit me to join. I was not permitted to join. So, if I was not permitted to join, how can they dismiss me, my lord? On the same ground, I was not permitted to join. High Court passes 2 orders, my lord, contempt court order.
Okay, come to para 3 and read the first 3 lines.
Of their affidavit, my lord?
And tell us, is this statement correct according to you?
Duly served.
It is most respectfully submitted that the reinstatement order was duly served to Shri Pritham Bhattacharya.
Yes.
So and so, and his acknowledgement of receipt was obtained. Consequent upon the reinstatement order, daily part 2 so and so was published regarding the reinstatement. True typed copy of so and so, acknowledgement of joining and order dated was published regarding the reinstatement. How do you meet with this?
Yes, my lord, this blank envelope was served, which is recorded in the contempt order of the High Court.
What was served?
Blank, my lord, blank envelope.
Well, a subsidy.
This is recorded. This is recorded in the, my lord, High Court order.
So there was nothing.
There was nothing inside. This is, my lord, very strange matter.
Will they go to this extent?
Yes, they have. This is regular. Kindly see, my lord. I'm just requesting your lordship to just read one order of the High Court.
I don't know what allegation.
My lord, one order of the High Court, and this
my lord, my learned friends.
All this is, my lord, considered by the High Court in this order of September, my lord. I'm, my lord, requesting your lordship, my lord, to kindly see this order of September 26, my lord, which is, my lord, page
that
63.
The High Court considered, set it aside, we accepted it.
Page, all this has been considered, my lord. All these explained. All, no.
Give us leave to.
All these, my lord.
Earlier order out 31st/10/25.
Yes, ma'am.
A statement made by Mr. Banerjee is recorded.
Yes.
It reads, Mr. Banerjee, learned additional Solicitor General of India, submits petitioner has in fact joined.
Yes.
And after joining, he has also submitted leave application.
Right.
Yes.
You were permitted to file a response by way of an affidavit.
He's filed it.
Correct.
And I'll take my law through.
And my lord,
Whether this is all stated, you are referring to the events occurred to prior to 31st/10/25. September something occurred which was prior to the order where
correct.
a statement is made.
Correct.
So whether that is in your reply, what
He says it. I'll take my law through what he has replied.
So
this statement is being made.
Why he had to go on leave again after reinstatement?
I never went on leave, my lord. Kindly see,
He's filed a reply. May I place that reply?
Lord,
therefore, whether it is stated in that reply.
It is stated. It is stated. I'll take my law through the reply.
Lord, may I request your lordship?
I don't know what is being said at the bar, my lord.
Lord of September 20.
I'll take my lords will go through the reply. I'm just
Understand,
requesting.
my lord, my request.
Is there anything like VRS or something?
My lords, but
No, is there
I
anything
don't
like
think so. My lords, not. He's been terminated. My lords.
terminated, removed or dismissed?
Dismissed.
No. Is it a case of removal from
Removal from service. Removal from service.
My lord,
Right. with nothing to be paid?
Nothing to be.
No retirement benefits, anything, except the gratuity or something?
Maybe except the gratuity. I'll find out.
No pension, nothing?
Wouldn't be, well, removal ordinarily wouldn't be.
My lord, I was not allowed and permitted to join after the High Court order, my lord.
I filed by my learned friend's client.
There is a difference between, my lord, reinstatement and, my lord, joining report. No joining report has been filed.
Please see
all these explanations and orders were, my lord, dated June 20.
You have not filed any reply, na? Affidavit.
He has.
I can file
Malos will, no, better reply. He wants to improve on that. Malos will see the reply which has been filed.
I don't understand, my lord. My learned friend, my lord.
Where is your
See the reply. He now wants to change his
additional affidavit? No.
Yes.
I don't understand, my lord, this
Yes,
anxiety.
The latest affidavit, Malos will read his objections at page.
I will show, my lord, how
5,
the contemner has
6 and
filed
7.
made a false statement, my lord, before your lordship.
Malos, page 6, page para 5, 6. Page 6 is and 6 and 7. Middle of the page. Middle of the page 7.
Of my reply, despite orders, para 3, my lord, quotes the order of 7th of June, which says I should be joining, my lord, next day. Then, my lord, para 4 is the order of September, which I was referred to. Joining report of the petitioner has not been placed on record, nor the respondents have mentioned when the appointment letter was issued. Respondents are also directed to produce the joining report as well as the appointment letter, which has not been done till today. Which is why, my lord, your lordships on the last date asked him, please, my lord, file the joining report. Till today, he cannot file the joining report because there is no joining report at all. My lord, no joining report has been, my lord, issued at all in case of the petitioner. All these documents of, my lord, reinstatement has been considered by the High Court in the, my lord, judgment and order of September 23. And, my lord, till today, no joining report has been, my lord, issued. And then kindly see the circumstances, my lord. I was confined to a COVID room. Did not top of page 7.
How can he be in COVID?
He did not permit the deponent to join as per High Court order, detained the deponent in a damp, cold, abandoned COVID room of another unit with restriction of entry, neither floor nor roof, even washrooms. Water supply was provided in the abandoned COVID room. Deponents also states that on...
Why were you confined in a COVID room?
My lord, just, my lord, out of spite and out of, my lord, I was singled out and punished.
Because he joined. How can he be confined to a COVID room if he hasn't joined? Well, he does.
My learned friend...
Well, he says in his own affidavit he joined.
His anxiety, my lord, is surprising. He's not allowing me to, my lord, place my case.
Case fairly. With being unfairly placed, of course.
And, my lord, from September, the High Court orders that till that date, no joining report has been placed. Your lordships on the last date says, please place the joining report. He does not place the joining report till today. That is why my learned friend, Lord, has made a false statement before your lordship. Which is why this anxiety.
My lords will see.
It's a very serious matter, my lord.
My lords will come to his objection.
He produces, my lord, documents which are dated June of 23.
Place page 7.
June of 23. Envelope was given in this order.
Sir. We assume that it would have been a case, would have been reflected when you submit a receipt in response to the letter, joining letter of 8 June. Please, if you have the copy of the affidavit,
yes, my lord.
The receipt where the sign is made by the respondent under his signature, received headquarter order dated 8 June. If your case would have been that it was only an envelope,
yes,
that could have been reflected, as you say, and he is assisting you. This could have been a statement, first statement in the receipt. I have received only a blank envelope.
My lord, that is, my lord, reflected in the High Court order. Your lordship may kindly see page 72.
That is earlier to this.
No, that is the point, my lord. I am so obliged, my lord. This is post, the High Court order is post all this. All this was argued before the High Court.
Even this receipt, why you failed to say that you received only the blank envelope?
No, that is observed in the High Court order. Lordship may kindly see para 10.
The first dismissal.
Kindly see page 72, for a moment. Petitioner has also produced 2 sealed envelopes sent to him. The said envelopes, though seem to be sealed, looks that both the envelopes are empty from inside.
The first dismissal which was set aside.
Empty from inside, and there seems to be nothing in the said envelopes. The High Court is observing this.
You take instructions from the authority, whether there is anything like voluntary retirement or something like that. We can modify the order. If you don't want him, we will not force you. Let him go. But see if we can. कितने साल की नौकरी हुई आपकी?
2002 में भर्ती हुआ सर। मेरा इस नौकरी में मेरे पिताजी का डेथ हो गया, माता का डेथ हो गया, सब सर पूरा फैमिली सफर कर रहे थे।
हाँ, लेकिन आप कहाँ पे काम कर रहे हैं वो तो मालूम है ना आपको? हाँ, और आर्मी में है ना? हाँ, आर्मी की डिसिप्लिन तो आप जानते हैं ना?
सर मेरे पिताजी नहीं है, दादी माँ का डेथ हुआ था सर, मैं श्राद्ध में गया हूँ, मेरे एसीआर से
नहीं, आपको जहां भी जाना है आपको परमिशन लेके जाना होता है। आप आर्मी ऑफिसर कहे जाते हैं, कहीं जब भी मन हुआ आप नहीं निकल सकते।
हमने पूरा पेपर
जस्ट टेक इंस्ट्रक्शंस if we can help him to some extent, that's all.
I'll he just submitted resignation stating that if they can.
He resigns if he gets something. Otherwise, he'll lose everything.
I'll take
Ask him.
I'll ask. That is all that I.
Just on humanitarian grounds.
I'll ask. But I know the army, and I know Lordship, the army, every other institution is written. The army is always very on discipline. But
You are showing army like this?
No. My lords, I'm just.
Whether it is army, whether it is air force, whether it is navy, whoever that person may be, is not above the law.
Of course.
It is the Supreme Court of the country requesting you, Mr. Banerjee.
I know that.
Try. Understood? And never raise your hand like this. Army. Army, we have due respect for army. Absolute.
I was only.
They are the people whom we respect the most. But that doesn't mean if something falls from the court of law,
not at all.
They must consider it.
Of course. I will.
I will put it after 2 weeks.
I'm sorry, Malaj.
May I just make?
Malaj, I apologize.
All right.
Malaj, may I make a small request, Malaj? I have spoken to the other side, Malaj, myself. Once have indicated in item 43 Wednesday, Malaj. Kindly keep it on Wednesday. That is 10th of next week, Malaj.
Okay,
Malaj. Item 43.
43.
And top of the board.
Milord, no joining. I was not permitted to join.
We'll try to help you.
Right. I'm obliged, Milord.
If something is workable, something is worked out well and good. Otherwise, the only option would be to challenge that last order of dismissal.
Milord, that I will explain, Milord, on the next
Lordship has said, I'll take it back. And Lordship has fallen from the.
We request you. It's not even an order. Understood? An ordinary man, he has committed a mistake. He has served you for how many? 20 years?
9 years.
9 years? Look into it. If you can do it.
Milord, can it be a short date?
After 2 weeks.
Obliged.
Let's taking it after vacation. So I'm just sort of 2 weeks.
In January, Mera.
Obliged.
What is that matter left?
Obliged.
In item 49 canopy, any other? Lordship, in item number 48, I seek any specific date, Lordship. Sir, मेरा कोई criminal offense नहीं है.
आपके वकील साहब भी वहां तक चले गए, लेकिन आप यहाँ के यहाँ ही रह गए.
डेथ हुआ था उसके साथ है सर, साथ के वजह से गया हुआ था सर.
हमने रिक्वेस्ट की है, देखते हैं कि उनके यहाँ से क्या जवाब आता है.
49 canopy.
49 is there.
Next week.
What?
Next week.
Okay, next.
49.
Any urgency?
There is an interim stay operating against us, but my lord.
Interim stay of?
My lord, surface proceedings, my lord. We cannot proceed further. My lord.
Who are you?
I am the
I am the debtor. I am the debtor. I moved an application
are who?
under section 17.
Who are you?
Borrower. Borrower, yes.
You have defaulted?
Defaulted, I moved an application.
Fine. They must have initiated proceedings.
Proceedings.
Sufficing?
Yes.
What happened thereafter?
Thereafter, I approached the tribunal.
Why?
Under section 17.
Why?
Challenging these proceedings.
Why?
And in
On
which I
what
moved an application for appointment of the commission. That was rejected, and I challenged the that order before the appellate authority. Appellate authority imposed a condition that 30% has to be deposited. As per this court's order, which says that this is only an interlocutory application.
Oh, that issue.
That issue is
Achha.
pending before this court.
My lord,
So it can be decided.
only two things.
I will file a rejoinder also.
Ek second. What is the amount due and payable from him?
2 crore 90 lakhs, my lord.
Why he wants appointment of a commissioner?
No,
For what?
He says, according to him, he says that this is an agricultural land. Let the commissioner go and inspect that. And when we took land from him for mortgaging it, he himself gave an affidavit and documents to show that this is a land which has been converted as a residential.
So under the sufficing proceedings, you are not supposed to attach agricultural land.
He's trying to take that advantage.
Okay. When he came to you
For loan.
the revenue records, the title deeds, everything showed non-agri.
That's right. Residential. He himself gave an affidavit. I will.
What? Residential?
Residential. It is for residential purposes. That area can be used.
What is the area?
My lord, it's for residential purpose only. My lord, it's a plot of land. Plot basically.
It's a house?
It's a house, residential building.
Total area is how much? If it is a house,
Please.
this house is on a land at measuring how much?
I will just give me 1 second.
And how do you propose to repay this loan?
I have to take in section.
Huh?
I have to take in.
Think, forget about agricultural, non-agricultural.
Take in section.
You borrowed the money. You have to pay to the bank.
I have to take in section to that extent. These properties are also, I have to
Who
I will
gave
file a
you this,
rejoinder.
who gave you this idea? Okay, this is an agricultural land. You gave him that idea?
No, it's they seek the affidavit during the time of this loan enhancement.
The revenue record shows that this is an agricultural land.
It's an agricultural land. That's my condition.
Were they blind when they sanctioned the loan in your favor?
They might have.
See your conduct. See the conduct of your client.
I can understand. I will take in.
You have deprived the bank of public money, and you are just enjoying the interim relief. Isko khatam karna padega. Isko Wednesday laga do top of the board.
Great.
Right?
Please.
Have you filed your reply and everything?
We have.
Fine.
Great.
So on Wednesday, you ask your client to be here. How he proposes to repay.
Great.
This defense is not going to work. Agricultural, non-agricultural, it has to go.
Great.
Take.